Ecomas Mutuse here in Parliament. So we shall be looking to see how that plays out. But of course, also security has been bolstered outside and inside Parliament. Remember, also members of Parliament had also asked that they be protected even after this motion was tabled. And we've seen that also some members of parliament, rather some from Nyeri, for instance, have had a change of heart since that motion was tabled. I'm not alone. I'm with Stephen Leto and Emmanuel To here on the sidelines of this, and I'll just like to pick some questions for Leto. Perhaps Leto, what do we anticipate today from where you stand?
Well, already we have acquired the order paper, and of course this pains of a busy day for the National Assembly members, because after the tabling of the impeachment notice of motion, because what was put last week was the notice of motion, and today as the session kicks off, we anticipate two major things to happen, Olatenges, starting with the tabling of the public participation report. Remember, the National Assembly Speaker through the Clerk of the National Assembly, Samuel Njoroge, had gazetted and outlined that there will be a public participation across all the 290 constituencies. They had at first started on Friday to put all the constituencies together in a particular county and put them to go to a public participation in one particular area, until again the court directed that 290 constituencies must individually hold the public participation, and it is that report that will also be tabled in the National Assembly today, so that we are able to see how was the public participation like, how many members of the public turned up, what was the views that were collected by the 290 member constituencies. And of course, in the order paper, as we've already seen, Melita, we have seen all the 291 members of parliament who had appended their signatures to the impeachment motion. All have been printed in the order paper today, and of course all the 11 grounds as well have been put and have been printed on the order paper. And of course, the Speaker of the National Assembly was very categorical. After that meeting, there was a directive that the Speaker of the National Assembly gave how the rundown today will be looking like, from when the Member of Parliament for Kibwezi West constituency, Ecomas Mutuse, will be formally tabling the motion and prosecuting his case. Then the member, he will be given 1 hour, that is 60 minutes, to present the motion before the House. And of course, the majority leader, Kimani Ichung'wah, as well as his minority counterpart, Junet Mohammed, have each been given 10 minutes to contribute into the motion. And of course, the members have all been given about 7 hours or so. That is about what we'll call about 5 minutes per member. But of course, that might be changing. That of course might be changing, and of course we are looking at what is coming into Parliament in terms of the public participation. We have some of the constituencies that have recorded how the public participation was going. For example, part of the report that we are having is that Ainabkoi constituency, for example, had about several people had about several people coming out. You saw 13% of those who turned up in Ainabkoi saying, I do not support. Aldai, the same 94% in Aldai constituency. Those who turned up for that exercise say they support the impeachment of Deputy President Rigathi Gachagua. Balambala constituency. Funny enough, in Balambala constituency, 100% of those who turned up say they are in support of the impeachment of Deputy President Rigathi Gachagua. But in Bomachoge Chache, 68%, Bomachoge Chache in Kisii County, 68% said they do not support the impeachment of Deputy President the impeachment of Deputy President Rigathi Gachagua. I beg your pardon. Bondo constituency, 3% only say they do not support the impeachment, while 99% of Bondo constituents who turned up for the public participation said they want Rigathi Gachagua, the deputy president, ousted from office. Of course, that is the kind of the public participation report that is expected to be tabled on the on the floor of the National Assembly this morning. We anticipate, of course, a lot of interjection, the ventilation of that particular motion. But of course, the height of the day today is the appearance of Deputy President Rigathi Gachagua before the House to defend himself, to pick it from where he left yesterday during the live interview. We do not know what else he will be presenting to the floor, because what he did was presenting case by case. But the height of day again is the vote, because it is a special motion that has to end today, which means before midnight a vote must be taken and members of parliament will decide whether to impeach Gachagua or let him go.
Well, on that note, of course, Stephen Leto, also the Deputy President, said that he will challenge the public participation process, which he has termed as a sham. And of course, we are looking to see how that will play out. Remember, the impeachment motion is in accordance with Standing Order 64, 65 of the House, and of course, the Constitution of Kenya, Article 145 and 150. So we are here, your ears and eyes on the ground, of course, to bring you details as it unfolds from Parliament buildings. Back to you in studio, Sam.
Thank you so much. Melita Oleteges from Parliament is speaking to us with Stephen Leto, and also Emmanuel Tor is there, and they'll be keeping us covered from that side. But having us covered in Nakuru County is Marian Nyambura. Marian, good morning. Very interesting scenes we saw on Friday and Saturday during the public participation. What are you seeing today?
Well, indeed, Sam, it's just a few minutes before the motion to impeach Deputy President Rigathi Gachagua is tabled for debate. And as much as other Kenyans across the country are waiting to see what will happen, also in Nakuru, the expectations are high. And I'll be speaking to some of the residents here at the toy market in Nakuru CBD, and they say that they'll be following the proceedings live on TV as well as on radio. But let me just get views from them regarding the expectations today. Labda tuanze tu na jina lako, tuambie kuhusiana na hii leo. Tunajua kuwa hoja hii inaweza kujadiliwa na wabunge. Pengine maoni yako ni gani ikizingatiwa kuwa leo ni siku ya kihistoria nchini?
Okay, kwanza majina yangu naitwa Joseph Thuo, niko hapa Top Market, na nashukuru sana kwamba leo ni siku ambayo Wakenya tutajua ukweli wa mambo, kwa sababu kumekuwa na accusation ya our DP na kabisa aliweza kujiongea jana, na tukajua siri nyingi ambazo zimekuwa zikifanywa, na saa hii tunatarajia kwamba wabunge ambao walikuwa wamepewa pesa ndio waweze kumbandua. Saa hii hawana la kusema, kwa sababu DP aliweza kujiongea na akatoa siri ambazo hatukuwahi zijua kuanzia pale mwanzo kwa serikali ya Kenya Kwanza. Kumbe mambo mengi president aliweza kuyanzisha, na kama mambo ya sharing zote tumekuwa tukisikia kutoka kwa Gachagua, na kumbe ni kitu ambacho president mwenyewe alianzisha na kaweza kusign. Kwa hivyo our DP anakuwa sacrificed kwa sababu ya kuwa truthful, na nataka kusema kwamba our DP mambo yote ambayo amekuwa kiongea na mambo yote na siri zote ambazo zimekuwa zikifichwa ni serikali. Yes, serikali tunajua ni siri, lakini siri zingine ni za kuumiza mwananchi, na ndio our DP akasema kwamba haya mambo lazima naye aweze kuyaweka kwa mwanga. Kwa hivyo tunatarajia mambo makubwa na mazuri, na our DP atatokea akiwa mshindi, na hawa bunge ambao walipewa pesa. Hii mambo yote si mambo ya wabunge, tunajua ni pesa president alitoa aweze kunyanyasa our DP, na tumekuwa tukiona kuanzia mwanzo wa mwaka na last year, na kwa saa hii hawawezi tumia maamuzi ya watu 50 million ambayo walifanya, wakaweza kuweka our deputy president Mr. Rigathi Gachagua, na hawa wabunge ni wabunge 200 na kitu. Kwa hivyo kula za watu 200 na kitu hazitafanya maamuzi za Wakenya 57 million. Kwa hivyo tunasema kwamba president, wacha kujificha na parliament, tokelezea useme kile ambacho unataka kufanya, na ulianza hii kitambo mambo, ulianza kugroom Mr. Didi akajua na akaondokea. Saa hii mna mpango wa kuweka Kindiki na DP haendi mahali, na tunasema kwamba tuko nyuma ya DP kabisa kama Wakenya.
Well, Sam, because of time, we'll continue to get more views from Nakuru residents as regards to this motion, and we'll give more details in our subsequent bulletins regarding what the residents of Nakuru will have to say as regards to this impeachment motion that is being tabled for debate in Parliament. Sam.
All right. Thank you so much, Amiral Nyambura from Nakuru. And of course, it will be a day-long coverage of the impeachment process at the National Assembly. Like Stephen Leto and Ole Tenges described, there will be several issues of consideration with the Deputy President according an opportunity to respond. The order paper says 2.5 hours before the vote is taken. After the 2.5 hours, the move of the motion, in this case Mwengi Mutuse, will have 30 minutes to reply, and after that a vote will be taken. Crispin Otieno, we had him earlier, but we lost his signal. Now I'm informed we have him. Crispin, take it away.
Well, Sam, I'm still having residents from Kisii County who have been patiently waiting despite the earlier technical glitch. I want to just share with them, or rather to get their opinion with regards to what is happening today. We understand the Deputy President impeachment motion is resuming today at the National Assembly. Share with us, unaitwa nani? Alafu hali ikoje kwa mtazamo wako jinsi ambavyo mapendekezo ya kumbandua mamlakani naibu wa rais?
Kwa majina ni Douglas, ni mfanyabiashara wa hapa Kisii Town. Kulingana na yale ambayo Deputy President alizungumza jana, ni vizuri tu aende. Na akienda, mkubwa wake pia aende. Hao watu wawili wote walioana wakiwa wawili. Sembuze mmoja sasa amekuwa mbaya, ameanza kufurushwa na huyu mwingine akuwe mzuri. Kama ni kuenda, waende wote. Kama gari inaanguka na makanga ndani. Na dereva ndio anaangusha gari. Si waende wote.
Wacha tuweze kupata maoni zaidi na kuja kwapo.
Kwa majina naitwa Alfred Isaboke. Mimi ni mkaasi wa Kisii. Yesterday nilisikia maneno ya mkubwa Vice President. Actually he convinced me he has no problem. Kwa sababu ile mambo ya shareholding alielezea vizuri. Actually mpaka tukaridhika, it's true that these people are sharing powers. So the problem we have now is from the above. The president has a problem. He has to put his house in order. So as residents of Kisii, we support VP because hata sisi hatukuwa na yeye before. But for today, I'm for him and I agree wacha akae kwa ofisi aendelee kufanya kazi yake.
Asante sana. Wacha tupate maoni yako.
I'm Sati, a resident of Kisii County. Honestly, if there's people who are supposed to be impeached in this country are members of parliament, honestly, how can you impeach somebody by speaking the truth? Honestly, the Deputy President of the Republic of Kenya has no problem. Those allegations against the Deputy President, honestly, all of them are false. Instead of the members of parliament going to table a motion to impeach the Deputy President who was elected more than 6.2 fathers, people who elected him. Now you want to impeach him because of speaking the truth. The problem the Deputy President has is only speaking the truth.
Right.
So instead of doing that, let them talk about NHF and talk about airport.
Okay.
My name is David Mogeke Ondwari, a resident of Kisii Township. And also I'm the Secretary General Kisii Pamoja CBO. My opinion is that looking at the Deputy President, his argument of yesterday, the Deputy President has to go and is a must to go. Because in Kenya, while we have the sitting president, it is of no good manners. When the president speaks, that's the end of it. Hakuna sababu president anaongea anamaliza kuongea, deputy president anaongea nyuma yake. Of that thing, hiyo naona hapa hakuna heshima.
Let me give an opportunity to this lady over here. Share with us what's your opinion. Maoni yako ni hapa.
Okay, kwa majina anaitwa Gladys Luka. Mimi langu ni kusema ya kwamba wacha Gachagua akae kwa ofisi because kwa hii dunia kuna mtu afanyi dhambi. Hata tunapoangalia katika Biblia wakati ule mwanamke aliyezini aliletwa kwa Yesu, aliwaambia kama kuna yeyote afanye dhambi. Ni wengi hao wabunge wetu, hata wengine tuliwaelekta tujawahi uona. So huyu ndio ameona makosa. Mimi sioni makosa ya kutetea mtu jamii yako. Hata kama ni mimi ningetetea jamii yangu, acha akae kwa ofisi ama wote waende. Waza fresh.
I think because of time we'll be able to speak to some of you in just a short while. There you have it. Those are some of the sentiments from Kisii County residents. Some are in support of what is going on. Some are supporting the Deputy President, while some are also against. But all eyes shall be at the National Assembly, where the whole process will be taking minutes from now. Otherwise, I'll just leave it at that. Back to you, Sam, in studio.
Thank you so much, Crispin Otieno. Something was happening in there as we were transitioning back here in studio. And I'm still with Eric Theuri, Dr. Eric Omolo, Dr. Martin Olo, and Dr. Duncan Ojong. And we are at the conclusion phase, because in the next 7 or so minutes, Parliament should be on to commence the business of the day. And of course, the main business today is a special motion to impeach Deputy President Rigathi Gachagua. Dr. Martin Olo, I had not gotten to you, and we were talking about what Parliament will be doing today. So he thinks that you vote on each of the grounds at the National Assembly. So the 11 grounds, there are 345 members at least in the National Assembly. Some will appear, some will not. There is an option of voting electronically. There is an option of voting in a way that Kenyans can follow what is your vote. If you have to vote 345 11 times, that's a lot of time which may not be available. What do you think is the best outcome here, knowing also that Kenyans are very keen to see how their representatives are voting?
You see, Sam, what we need to understand is that there are only 3 grounds for impeachment. One is the violation of the Constitution, and the other is serious reasons to believe that the Deputy President has committed crimes, and the other is gross misconduct. So those are the issues. So the rest are charges that are answering to those issues. So one would say that, do you believe that the Deputy President has grossly has been found guilty of gross misconduct? So that would be, then of course everything else is an attempt to substantiate that.
Okay.
So I would see those are the 3 grounds upon which either there's a threshold on each ground, and therefore we vote on it that way, but not on issue by issue. For example, the issue about property and whether this property were found or bought with illicit money, that's one argument. And you can come and say, yes, this, that, and then you say, yes, there's corruption. And if that amounts to gross misconduct, you can come. If it amounts to a crime, you can come to that issue. Has Gachagua grossly violated the Constitution? I don't see any ground that points that whatsoever. Whatever is being alleged is conjecture. And like my friends here, what is happening is a political process. The legal process will begin after the decision that the Parliament makes. That's when now we'll deal with the legal issues, because what is the threshold to say that somebody has grossly misconducted himself? What is it that you want to say that because somebody said that this government of shares that he violated which constitution, and what's the threshold? So I don't see any of those holding water legally after. For now, they can vote. As I've said, it's going to be a lynching process. It's not a legal process. Where you have MPs who say they don't know how they even found themselves supporting it. Where you have people who are being threatened if they don't appear and if they don't vote one way or the other. That is not a legal process. So we will wait.
Sad.
What is it?
It's very sad what you said.
Yeah, but you see...
Because, I mean, he has only interacted with this thing through TV. But
so I don't read. I haven't read the motion.
Or read the motion.
Yes.
But apparently people who are placed in that thing, including Gachagua's own member of parliament, that have gone through participation as an individual, that is now going to have a whole day looking at those things.
You're
to him,
talking
it
about
has the MPs.
Eric Omombi.
Yes. To him, he has
we have
turned them.
information he didn't go for the public participation in Madeira.
To him,
I like the fact-checking that you're making on this.
He has the report.
Like Trump is not very happy with fact-checking.
Sorry?
He signed the motion.
He signed the motion, and he has the report. Public participation does not mean you have to be there and listen. You can see the report.
Yeah.
You know, there is no requirement for public participation that the MP must chair it. Actually, that is not the requirement. The requirement is that you get the report and look at it. But if you look at all this, if citizens and Kenyans, if the MPs put their foot down, they will have dented the issue of corruption, the issue of ethnicity, the issue of balkanization, once and for all.
You know, corruption has never been a political issue in this country.
Dr. Joang, I take interest that you talk about Rigath's own MP who went through public participation. There's a report that has been shared by Parliament just right now that Madeira constituency, in the public participation, 5,598 people showed up or filed their responses, and out of that 97.59% voted or ticked I do not support. 2.16% said I support. What should this do to the Member of Parliament of Madeira?
Nothing. It is that simple.
There is no mathematical formula to how much weighting you give public participation. As it is given, it is very important view. But the MP stands at a position of trust where they are told at this time as the Member of Parliament, listen to us. If you are to disagree with us, have very good reasons. And we will have very good reasons.
Do we have public participation law in place?
There is no public. No.
So whatever is happening is a charade.
I want us to lose, I mean, not to lose, but to close, to tie the loose ends as you conclude.
You said very bad things.
If you don't have a law, what is it that you're going to, what standard are you going to?
Constitution.
Sorry, Dr. Komolo, so eventually, if this matter gets to the courts, there's a spillage happening somewhere. If this matter gets to the courts and they are called to interrogate, can they go to the merits of the allegations, or are they just to look at the procedure followed?
We are still a bit far from there, but the general trend has been that courts have intervened when it comes to the issue of the process, particularly on this conversation around public participation, and obviously to try to bring sanity in the process of impeachment, because particularly for counties, it's often hurried, often the MCS often proceed even after there's a court order in place. I think that's the case in Kericho at the moment. So it may be speculative, but I did hear the Deputy President say that the public participation was a sham. That's a ground that will eventually end up in court. Having said that, I don't think that this process should even get to the stage where we now go to the High Court to intervene. We do not need to overstretch the mandate of our courts in political processes, particularly something as significant as the impeachment process of a president or a deputy president, because we should ideally be getting it right from the outset. And that is the question that I think Dr. Joang and Dr. Lau have been debating here. What is the role of an MP? Apart from appending their signature, which is a formal process to bring the motions to Parliament, what then do you do to ensure that the people you represent have their voices heard? Because MPs are not there to speak for themselves. They're there to speak for the people who elected them. In a particular case of Madeira MP that you've shared the data, I'm not sure that 5,000 is representative of the real population of Madeira, but this could be the people who are either mobilized or who were, you might say, in terms of civic education, were more conscious to then participate in the process even at short notice. And if it is true that 95% of them have said no, then I don't think the Madeira MP has latitude to then go against their wish, because then who is he representing?
You know, it's interesting you said that if it is true, are you doubting the report of Parliament?
I've not seen it. Remember Sam, I don't represent Parliament. I don't represent Gachagua. I don't represent Mwenge Mutuse, the MP and all that.
Yeah.
I look at it in terms of the objective standpoint of the Constitution and what we expect impeachment process to amount to. Having said that, and I did say this earlier, I still expect Parliament to restore its glory as an institution that represents people, that is not only seen to be independent, but is actually independent. And that means all MPs have then to interrogate their conscience in terms of where we are, what do we want for the country at the moment, and whether impeachment or lack of it is the right thing to do at the moment, particularly when there are several people in the country saying, look, our priorities are A, B, C, D. I still expect them to give the Deputy President, I'm not sure 2 hours is fair. I expect them to give him a lot of time because this is also a career-changing process. Impeachment, remember, when successful to the end, then you cannot hold public office for, I think, forever, I think. In other countries, normally about 10 years or so. So when you're doing things that are career-altering, then you expect that the process be fair, reasonable, objective, and hopefully not influenced by graft. Because there are already conversations that man is exchanging hands here and there. But look, I'm going to spend the rest of the day watching this. Remember, all of us here are going to vote in 2027 one way or the other.
Yes.
And we will be voting based on what we see our representatives to be objectively acting on, and not going because I am made to understand parties have not openly whipped their members. If that is the case, that means party leaders understand that this is one of those spaces where MPs should be acting independently and objectively, of course, and senators later. And if we elect you and you don't do that, then of course you will meet the consequences in 2027. Until then, let's wait for the prosecution of the grounds, and then the response of the Deputy President and the objectivity of the voting process.
Interesting. And for you, Wakili, as we conclude, he quite avoided what I asked about the specificity of the focus of the courts. Will it be on the process or will it be on the merits in a situation where Parliament, both the National Assembly and the Senate, confirms some of the allegations and says they're impeachable? Can the High Court or the courts, can they alter that, or they'll just look at the process?
I don't think that the courts will conduct a merit-based review of the allegations with a view, ordinarily what we would say is that perhaps the courts reviewing it and determining that they would have arrived at a different conclusion than Parliament. The courts would not undertake that kind of exercise. But for example, if the Deputy President is removed on the basis of allegations of violation of the law, then that is an area which the court may want to look at in terms of, if you are saying that someone has violated the law, what are the processes? Because it is a bit intricate to just make an allegation you have violated the law, if then the certain processes may not exist to actually demonstrate to a desired threshold. So it might come to a question of threshold. If you are saying, for example, someone has violated the law, what do we look out for in terms of that mandate? And you would understand that when it comes to questions perhaps of the violation of the law, Parliament may not have primacy of determination of those issues, because that could be a mandate that is reposed elsewhere. And as we understand the process of impeachment, that sometimes because someone holding office has committed a crime and there is evidence of commission of that crime, but that person is using the office to prevent accountability for that crime, then an impeachment process is introduced for purposes of seeking accountability for the violation. of the law. So I think those are the issues that we are going to see play out. The other critical thing that we are going to see play out is that this is the first time that as a country we are conducting impeachment of in the deputy presidency or under the Article 145 procedure to 150.
Right. So
there is a bit of innovation that is being done by Parliament. For example, the innovation that they did with regards to public participation.
Yep.
Would that be adequate? And of course, the other question would be, you look at it and you almost get a sense that Parliament, in a way, intended to carry out a referendum on whether the deputy president is actually popular or not popular. So, again, that is something that the court may look at in terms of this person got elected into office, you conducted public participation. Fortunately, the court did intervene and say, roll it out to
the constituency level.
To the constituency level. Again, that might become a problem. The other question might become, and this is also a question that the deputy president has been asking, before I give my response, can you take this to public participation? Because then the other side is not available to the public, and so they give a biased feedback on the basis of the allegation. And now, what has come out is that some of those allegations, for example, where what the deputy president was saying, that he was sold a piece of land by an existing member of parliament way back before he got into office, and that member has signed. If that information was out there before it went for public participation, would it perhaps have changed the views of those who gave a yes or no opinion? So those, I think, would be questions that the court may interact with. And unfortunately, and we all know this, that there was a law that was intended to guide the impeachment process, which has not been enacted. And that law would have probably filled in these gaps and would have looked at all those issues. So in the absence of that law, then the court then would have to look at what the constitutional principles, because the Constitution then has to be interpreted holistically. We'll be looking at what does public participation mean. In this instance, should they have just looked at one side or two sides? Those will be things that the court will be looking at, and those ideally are also procedural issues that ultimately have a bearing on the merit of the decision that eventually was reached. So that's what I foresee playing out.
Okay. Interesting. We're still expecting for the session in Parliament to commence. The members of Parliament are walking in for the start of the sessions. Now, I have a few minutes remaining before you take a break and come back to the House. I don't know if you have something to say as you close.
Public participation does not turn to be a trial by jury. And that's why even courts don't come and say, hey, you guys, you have been listening to this case. What do you think? Is this guy guilty or not? There is those who that responsibility is put on their shoulder because it is moving or metamorphosing to people demanding that it's a trial by jury, sort of. No, the responsibility is placed in the hands of the member of parliament. And I like what Theory is saying. The Constitution did not envision them to be lawyers, to be judges, but in their many and in their various skills, they are entrusted to be the people who will do this. Instead, the Constitution gave them a higher threshold to impeach, which is 2/3. The court comes in, and the court are always being invited to some of this, which we call politicization of court. They have been invited 20 times. They have rejected those invitations. That court generally can only look at process, but they are not going anywhere. Even if you look at the Wambora jurisprudence, and we are building jurisprudence on impeachment because this is the first time now that the deputy president is being impeached, the court cannot turn to be the parliament. That role, the same constitution that gave court their powers, gave it to the parliamentarians. Now, if they do things and the people don't want, the politics have a way of balancing that. I think that this impulse to beat up the parliament, to talk of parliament as if they are not an institution of the constitution, and try to run as if the courts are the temples of justice and they don't operate in a vacuum, not recognizing that there is the parliament of the people, is going to run amok. If I was part of the legal team, I would have really made the deputy president talk so well about parliament. You don't throw, they talk of throw mud at a dog so that you can justify the allegation of they are corrupt, they are not, they have not looked much at this issue, they have ill motive or ill will. We'll just give them more appetite to impeach you more. This is a dignified house.
Is it a possibility that they're being whipped from outside the house?
It doesn't matter. You know what is bad is undue influence. Influence is there. Even when I came here, there is influence to where to park. What the law does not allow is undue influence. So they are parliamentarians, they are politicians. There will be at any time they operate. There is various faces. There is the public pushing. There is the party. There is the personal. But are they undue?
There's a direct answer. Yes, they are being whipped. Yeah. No, they are being whipped. The issue is not undue. They're being whipped. When Republicans are called to vote, they vote the way of the party. So parliamentarians are being whipped. And that is also part of the parliamentary procedures. I want to say this, Sam, because it's our closing. There is a way in which Dr. Yuang speaks and wants to give the impression that because the impeachment process is a parliamentary process, it can violate the Constitution, it can violate the Bill of Rights, and that it can obviate such a person who is aggrieved to seek redress further. Nothing could be further from the truth. As a matter of fact, public participation was not meant to be a jury system. However, it was meant to reaffirm Article 1 of the Constitution in sovereignty of the people, and to affirm the provisions of Article 10 of the Constitution, making it a requirement in terms of public participation and also good governance and accountability, transparency, and openness. So that when you take to a people a motion which you have not given them time to process, they have not understood even the basis upon which you have made those allegations, you are expecting them to act in ignorance and therefore without any relevant information that can make them make good decisions. So public participation is an ingredient well embedded in the Constitution to enable people to continuously hold those they delegate power to. Parliamentarians are delegatees of the people. To that, the executive is a delegatee of the people. The judiciary is a delegatee of the people. So public participation is not a charade. It's not something you just do over 4 hours without proper information and you come back and you say, we did it. It is a serious, sacrosanct exercise that should not violate the people's sovereignty.
A very important profession, because it is one of the national values and principles of governance. Yes.
Sam, you know, this being a politicized process, you expect some of my ordinarily very objective friends to take sides. So I'm not very surprised that Dr. Juang and Dr. Olo are taking sides on particular issues here and there, even when they know the reality. The reality is that the High Court has supervisory jurisdiction over public institutions, including Parliament. And if this process is questionable at a particular stage, then the High Court will obviously have jurisdiction to then interrogate the entire process. And no less than the most important person in the entire thing, the Deputy President has said so, that they are going to court on certain grounds.
Okay.
So we expect this to be interrogated by the High Court in a normal way. And, you know, we are in a country where ordinarily political leaders attack courts almost every day when things don't go their way.
Okay. All right. I have to thank all of you. Eric Theuri, former LSK president, Dr. Eric Omolo, advocate, Dr. Martin Law, from the head of public law at the District University, and Dr. Dankaro Ojwang here from, should I say, Nairobi Rivers Commission, your role at the university?
Public defense.
From the political trenches.
Okay, so the Speaker of the National Assembly has got into the House. We leave you with this for the next couple of hours until the conclusion of the process. Stay tuned to Citizen TV. Bye for now.
Waheshimiwa, tuombe. Ewe Mwenyezi Mungu ambaye kwa hekima na wema wako umetoa nyadhifa za viongozi na mabunge kwa ustawi wa jamii na utawala wa haki wa wanadamu, tukusihi utazame kwa neema nyingi sisi watumishi wako ambao wameridhika kutuita ili tutekeleze shughuli muhimu za jamhuri yetu. Tunakuomba uteremshie baraka zako sisi tuliokutanika hapa, na utujalie tuyatende na kufikiria mambo yote yatakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili utukufu na sifa zako siendelezwe, na ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. Honorable members, we have quorum to transact business. Clerk.
Order number 1, administration of oath. Order number 2, communication from the chair.
Take your seats. Member for Trans Nzoia, take the nearest seat. Honorable members, I have a short communication in relation to the motion for the removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, as the Deputy President of the Republic of Kenya. Honorable members, as you will recall, on Tuesday, 1st October 2024, the member for Kibwezi West, the Honorable Ekomas Mwengi Mutuse MP, gave notice of a special motion seeking a resolution of the House for the removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, as the Deputy President of the Republic of Kenya. Thereafter, upon consideration of the notice, the House Business Committee, at its sitting of the same day, resolved inter alia that the sitting of Thursday, 3rd October 2024 be suspended, which it was, that in the intervening period, the Clerk of the National Assembly collects and collates public views on the proposed impeachment on Friday, 4th October 2024. Members of the bar, take the nearest seats. Take the nearest seat. Okay. That a procedural motion be moved to provide for the speaking time during the debate on the special motion, and that consideration of the special motion be undertaken today, Tuesday, 8th October 2024. Honourable members, as you are aware, public participation sessions were held on 4th and 5th October 2024 in all constituencies. I also note that the public participation exercise, which commenced on 2nd October 2024 with the invite to members of the public to submit views, included the collection of physical and electronic views, some of which were submitted by Kenyans in the diaspora. Whereas the earlier directive by the House Business Committee had intended to centrally collect views from all constituencies at identified locations in each county, in keeping with the orders of the High Court sitting in Kerugoya dated 4th October 2024, the collection of views was extended to 5th October 2024 to include all 290 constituency offices and the 47 county women representatives offices, being offices under the Parliamentary Service Commission. This additional time and coverage ensured the inclusion of a higher number of respondents from across the country. Notably, this extended time also saw the submission of additional views through hand delivery to the office of the clerk, as well as through electronic means. Honourable members, on behalf of the House Business Committee and indeed on my own behalf, I wish to appreciate you for your support during the public participation sessions and commend you for your conduct during the exercise. You took a lead in ensuring the public were well informed of the process and refrained from commenting on the merits or otherwise of the motion, whether in public or on the media. This is how it is supposed to be. Contrary to media reports on the general absence of members in the various venues at which public participation was conducted, I wish to clarify that the absence was in keeping with the requirements of the standing orders. Having said that, honourable members, I wish to inform you that the views collected during the exercise have since been collected and compiled into a report which was noted by the House Business Committee at its meeting held yesterday, 7th October 2024. The House Business Committee has designated the Honourable Millie Odhiambo Mabona MP, one of its members, to table the report on its behalf under Order Number 5. At an appropriate time in the course of today's proceedings, I will allow the Honourable Minority Whip a maximum of 15 minutes to give an overview of the process undertaken and the contents of the report. It is expected that as the House debates the motion, members will take into consideration the views of the public as expressed between 2nd and 5th October 2024. I therefore call upon committees to take a keen interest in the report and isolate matters that fall under their respective mandates for possible consideration, reporting, and approval by the House. Honourable members, may I remind the House of the resolution on the limitation of time as resolved on Wednesday, 2nd October 2024. The mover will have a maximum of 60 minutes in moving and a maximum of 30 minutes to reply. All other members will have a maximum of 5 minutes except the leader of the majority party and the leader of the minority party and the member seconding the motion, who will each have a maximum of 10 minutes. This is in addition to the 15 minutes allocated to the minority whip to highlight the contents of the report of the public participation. Honourable members, permit me to also remind members of the provisions of Part 14 of our standing orders on the rules of debate, Part 16, on the rules of debate that ought to guide today's proceedings. Notably, members should strictly restrict their contributions to matters that are relevant to the motion before the House and not the provisions of Standing Order 91, responsibility for statement of fact. The Standing Order notes that a member is solely responsible for the accuracy of any facts which the member alleges to be true and may be required to substantiate any such facts instantly. Additional only members will recall that ordinarily Standing Order 95, closure of debate, and Standing Order 96, adjournment of debate, allow a member to hasten the conclusion of a debate on a motion or delay the conclusion of a debate on a motion, respectively. However, these two standing orders do not apply with respect to the consideration of a special motion, such as the one that is before the House today. I will therefore not entertain any call for the mover to reply or any dilatory motion to be moved until the debate scheduled for today is concluded. Honourable members, I'm sure that you are all aware of the rules of natural justice which require that no person should be condemned unheard. This rule is embodied in our Standing Order 67B2, right to be heard, and pursuant to this standing order, I will accord the Deputy President and or his representatives that opportunity to be heard at 5 p.m. for a maximum of period of 2 hours. Thereafter, the mover will be called upon to reply, following which the House will proceed to vote on the special motion. Further to the communication issued on 1st October, I need to not gainsay the need for the House to conduct itself in the most decorous fashion during today's proceedings. For the best use of the time allotted to members' contribution to the motion, I urge that each member be listened to without interruption. Honourable members, as we commence today's proceedings, permit me to note that I'm aware that yesterday, the Deputy President of the Republic of Kenya held an interview with the local media in which he laid out his defense to the special motion before the House. Whereas Standing Order 85 prohibits members of this House from anticipating debate of a motion for which notice has been given, the Standing Order, when broadly interpreted, also extends to non-members, especially persons affected by such motions. Noting that the special motion is scheduled for debate and voting today, I believe that the Deputy President ought to have exercised restraint and refrained from holding the press interview. It is noteworthy that the Deputy President has been given an opportunity to appear before this House to make his response to the motion in accordance with the rules of natural justice. Be that as it may, I will not wear the hat of a judge on this matter, but permit me to put it on record that the conduct was, to say the least, abhorrent and decided conduct in the light of the proceedings scheduled to commence the House. The House is accordingly guided and will now move to the next business. Members, take your seats. Next order.
Order number 3, messages. Order number 4, petitions. Order number 5, papers.
Majority Leader.
Thank you, Honourable Speaker. I beg to lay the following papers on the table of the House today, Tuesday, 8th October 2024, morning sitting. 1. Special audit report of the Auditor General on illicit financial flows in Kenya. Focus on management of tax exemption on public infrastructure projects by foreign companies for September 2024. 2. Annual report and financial statements of Kenya Civil Aviation Authority for the year ended 30th June 2023. 3. The annual report of the National Police Service Commission for the financial year 2023 to 2024. 4. The audited financial statements for the year ended 30th June 2024 from the Central Bank of Kenya. And 5. Reports of the Auditor General and financial statements for the year ended 30th June 2024 and the certificates therein in respect of the following. 1. The Retirement Benefits Authority, and 2. The Insurance Regulatory Authority. Thank you, Honourable Speaker.
Thank you, order members. Reduce the levels of conversation Minority Party Whip, the Honorable Millie Odhiambo.
Honorable Speaker, I beg to lay the following paper on the table of the House today, Tuesday, the 8th of October, 2024. Report of the public participation on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. Thank you.
Soda.
Order number 6, notices of motion. Order number 7, questions and statements. Order number 8, special motion, proposed removal by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
Honorable Mwengi Mutuse Ekomas, you may take the floor. Begin. Can the majority and minority leaders approach the chair? Honorable members, as we start the motion, a slight variation on my communication. The majority leader and the minority leaders in the House will prefer to speak immediately after the subject of the motion speaks, before the mover is called upon to reply. I have acceded to their request and it's so ordered.
Thank you, Mr. Speaker, for the opportunity to move the special motion on the impeachment of the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua. Mr. Speaker and honorable members.
Start, Mwenge Mutuse, by saying, I beg to move the following motion and read the motion as it is on the order paper. What you probably can skip is reading out all the names of the members which you read. Just say this, the members who signed the motion are set out on the order paper.
Thank you, Mr. Speaker. I beg to move the following motion, that pursuant to the provisions of Article 145 and Article 151B and 2 of the Constitution and Standing Orders number 64 and 65, the House resolves to remove from office by impeachment His Excellency Honorable Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, on the following grounds. 1, gross violation of Articles 10(2)(a), B and C, Article 27.4, Article 73.1a, and Article 2b, Article 75.1c, Article 29.2 of the Constitution, and Article 147.1 as read together with Article 131.2c and d of the Constitution. That His Excellency the Deputy President has persistently made utterances threatening to discriminate, exclude, and unlawfully deny sections of the people of Kenya and regions of the Republic of Kenya equal opportunities for public service appointments and allocation of public resources. Ground number 2, gross violation of Articles 147.1 and 152.1 of the Constitution by undermining the President and the Cabinet and the effective discharge of national government's executive mandate. That His Excellency the Deputy President has made unilateral statements inconsistent with policy positions collectively adopted by the government and contradicted the President on critical matters of governance and the exercise of the President's function as a symbol of national unity. 3, gross violation of Articles 6.2, 10.2a, 174, 186.1, 189.1, and the 4th schedule to the Constitution by undermining devolution. That His Excellency the Deputy President interfered with the running of Nairobi City County Government by inciting citizens against lawful directives of the county government on the planning and relocation of markets and publicly disparaging the leadership of the county government and its decisions. 4, gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. That His Excellency the Deputy President has undermined the institutional and decisional independence of a judge through public attacks on a judge of the High Court of Kenya and falsely threatening to file a petition for the removal of the said judge in a matter in which he was a party. 5, gross violation of Article 3.1 and Article 148.5a of the Constitution on the fidelity to the oath of office and allegiance. That His Excellency the Deputy President breached his oath of office and allegiance on account of the utterances and actions attributed to the Deputy President under grounds 1, 2, and 3. 6, serious reasons to believe that His Excellency the Deputy President has committed crimes under sections 13.1a and 62 of the National Cohesion and Integration Act. That His Excellency the Deputy President has persistently made inflammatory, reckless, insightful, public utterances over the last 2 years in contravention of the law. 7, serious reasons to believe that His Excellency the Deputy President has committed gross economic crimes under sections 45.1, 46, 47A3, and 48.1 of the Anti-Corruption and Economic Crimes Act and sections 2, 3, 4, and 7 of the Proceeds of Crime and Money Laundering Act. That His Excellency the Deputy President has committed gross economic crimes, namely conflict of interest, abuse of office, and conspiracy to commit crimes under the sections highlighted by inexplicably amassing property estimated at Kenya shillings 5.2 billion that is incompatible with his non-legitimate income, and by trading with the office of the Deputy President through proxies. 8, serious reasons to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. 9, gross misconduct that is incompatible with the high calling and dignified status of the office of the Deputy President, a member of the Cabinet, and a member of the National Security Council. His Excellency the Deputy President has publicly attacked and undermined the work of the National Intelligence Service and its officers. Number 10, gross misconduct by openly or publicly insubordinating the President, who is the head of state and government. And number 11, the last ground, gross misconduct by persistently bullying state officers and public officers. Mr. Speaker, the motion is supported by a total of 291 members and is contained in the order paper. Mr. Speaker, in prosecuting this motion, it will be remembered that we gave the notice of motion on Tuesday 1st, 2024, and the House also takes public notice that law and procedurally, the Deputy President did address the nation yesterday, and therefore, part of what he said may form part of what I will be talking about. For purposes of members following what I will be presenting, I choose to be very methodical. I will read the ground. I will restate the provisions of the law that have been violated. I will then briefly state the facts constituting the particulars, and I will tie it up finally with the evidence supporting our allegations. This will make it easy for members to understand what it is that we are accusing the Deputy President of doing. In doing this, Mr. Speaker, I choose to be a prosecutor and I remove my political cap. I will therefore avoid the bravado and machismo that was displayed yesterday on television, and we will just talk about the law, the facts, and the evidence.
Order, members.
Mr. Speaker.
Order. Take your seats, McClap.
Mr. Speaker, honorable members, and Kenyans at large, if I do not talk about my departed relatives, it is because I do not think it is proper to use departed relatives to whip public emotions. It is because I do not think it is proper to use departed relatives to seek public sympathy. And therefore, much as I have also departed relatives, I will not talk about them. Mr. Speaker, before I begin going count by count, allow me also to state on two important questions, and I want honorable members to listen. Two things are important. That this is an historical moment and it is also a constitutional moment because Kenya, under the 2010 Constitution, has never dealt with the impeachment of a deputy president. However, we have dealt in numerous times with the impeachment of governors. And our courts of law have set the threshold on which impeachments should be considered. And I thought from the onset, it is important for me to set out the threshold on which impeachment should be considered, so that as I take you through the evidence that we have, you can gauge the evidence against what the courts of law have decided. Mr. Speaker, allow me to read paragraph 31 of Civil Appeal number 21 of 2014, famously called the Wambora decision. The Wambora decision is now the locus for most of the impeachment cases and has been cited with approval by our Supreme Court. In paragraph 31, the court stated as follows: our reading and interpretation of Article 181 of the Constitution, as read with Section 33 of the County Government Acts, shows that the removal of a governor is the constitutional and political process, underlying constitutional and political process. It is a sui generis process that is quasi-judicial in nature, and rules of natural justice and fair administrative action must be observed. What I'm going to read is the most important part. The impeachment architecture in Article 181 of the Constitution reveals that the removal of a governor is not about criminality or culpability, but is about accountability, is about political governance, as well as policy and political responsibility. Mr. Speaker, the coaching of Article 181 in the Constitution, which relates to removal of a governor, is similar to the coaching of Article 150, which relates to the removal of a deputy governor. And therefore, mutatis mutandis, what the Court of Appeal did state, that the removal of a governor is not about criminal or culpability. It is about accountability, political governance, as well as policy and political responsibility applies to the removal of a deputy president. Mr. Speaker, the standard, I am prepared this morning to discharge my burden of proof, because he who alleges must also prove. And I am ready to discharge it to the required threshold. Therefore, Mr. Speaker, in consideration of the time that I have been given, allow me now to go to the specific grounds. Ground number one, Mr. Speaker, ground number one, briefly. On ground number one, Mr. Speaker, we have alleged that the Deputy President has grossly violated the Constitution, and particularly Article 10(2)(a), Article 10(2)(b) and C, Article 27, Article 73, Article 75, Article 129, Article 147, and Article 131. Mr. Speaker, for clarity, allow me to read out the specific provisions so that members may relate with what we are saying. Article 10 is about national values and principles of governance. Article 10(2)(b) states as follows: the national values and principles of governance include patriotism, national unity, important national unity, sharing and devolution of power, the rule of law, democracy, and participation of the people. B, human dignity, equality, social justice, inclusiveness. Underline the words national unity and inclusiveness. C, good governance, integrity, transparency, and accountability. Mr. Speaker, we have also alleged that the Deputy President has breached Article 27 of the Constitution. Article 27 of the Constitution is about equality and freedom from discrimination. In particular, the Article 27(4) states as follows: the state shall not discriminate directly or indirectly against any person on any ground, including race, sex, pregnancy, marital status, and so forth and so forth. Important, the state shall not discriminate. Mr. Speaker, we have also alleged that the Deputy President has breached Article 73(1) of the Constitution. In particular, Article 73(1) is on leadership and integrity, and it speaks to the authority that is assigned to a state officer. And it states as follows: Article 73(1)(a), that the authority assigned to a state officer is a public trust to be exercised in a manner that is consistent with the purposes and objects of this Constitution. Article 73(2)(b) states that the guiding principles of leadership and integrity include objectivity and impartiality in decision making and in ensuring that decisions are not influenced by nepotism, favorism, underline favorism, other improper motives or corrupt practices. Mr. Speaker, we can go on and on to demonstrate in Article 75, under Article 75(1)(c), that the conduct of a state officer shall behave, whether in public and official life, in private life, or in association with other persons, in a manner that avoids C, demeaning the office that the officer holds. Mr. Speaker, I am taking time on this one because it is important to demonstrate that the Deputy President has not lived up to the high calling of the office that he holds and thus has violated the Constitution. Article 129 is about the principles of executive authority. And particularly, we have said that the Deputy President has breached Article 129(2). Article 129(2) states that the executive authority shall be exercised in a manner that is compatible with the principles of service to the people of Kenya and for their well-being and benefit. We have also alleged that the Deputy President has breached Article 147 in conclusion on this particular ground. And Article 147 is about the functions of the Deputy President. And it provides that the Deputy President shall be the principal assistant to the President and shall deputize for the President in the executions of the President's functions. Article 131 is the one that provides for the authority of the President. And under 131(2), it provides as follows: that the President shall A, respect, uphold, and safeguard the Constitution, and C, promote and enhance the unity of the nation. Promote and enhance the unity of the nation. Mr. Speaker, it is our allegation that on numerous occasions in the last 2 years, the Deputy President has used divisive language. He has described the Kenya government as a company. He has described the Kenya government as a shareholding company, where it is only the shareholders of the company who should benefit. And it is our contestation that that particular shareholding language contradicts and contravenes and violates all the provisions of the Constitution that I have highlighted above. Mr. Speaker, the Constitution does require, even at the preamble, recognizes that Kenya is a multi-ethnic society. We have about 45 ethnic groups in this country, big and small. And all of them are recognized by our Constitution, and all of them need to enjoy their equal rights. And the Deputy President has consistently told Kenyans in several places of this country that some will benefit from government and others will not benefit from government. Mr. Speaker, I need not waste a lot of time prosecuting this point, because those of you who listened to the Deputy President yesterday, he did admit that he has been using the shareholder and company language against Kenyans. The only thing that he did, and when there is an admission by the accused person, the prosecution does not need to prove a point. And therefore, I will be urging members of this House to find that this allegation is proved, and to find that the Deputy President indeed did admit that he has been using the shareholder language, only that for the first time, and this is important, Mr. Speaker, for the first time, the Deputy President did, while admitting, he said that he has been referring to the shareholder company language in reference to coalition agreements. The evidence that I'm going to present shortly will demonstrate that he has never, in his utterances in the last 2 years, talked about coalition agreements or power sharing deals that were signed before the election among the Kenya Kwanza political formation. He has been talking directly to communities. He went to Kajiado. He told the people of Kajiado that they do not have shares. He went to Kitui during a church service at AIC Kitui, and he told the people of Ukambani that they should not even be having a cabinet minister in government. He went to Bungoma and told the people of Bungoma that they have had too many appointments in government and the votes they brought are not equivalent to the votes they brought. He went to Nandi and told the people of Nandi that they are a major shareholder and they will benefit more than others in this government. And he has been using the language in direct reference to communities, not to political party formations. Mr. Speaker, without belaboring this point, allow me now to request that the evidence on ethnic profiling and divisive shareholder politics as contained in video 1 and video 4 be played for the House to take note of the evidence.
Hii serikali ni kampuni na ni ya shares. Si ndio? Ni ya shares. Kuna wenye kampuni, wale wako
Order, members.
Kuna wale wako na chache, kuna wale hawana.
The technicians who are playing, I kindly request that you repeat and you play it with on a higher volume. Please pause it. And I also request, Mr. Speaker, you direct that during the time that we are playing our clips, our time be paused. Please repeat so that members may appreciate and also Kenyans may know that we are not persecuting. We are not persecuting.
Serikali ni kampuni na ni ya shares. Si ndio? Ni ya shares. Kuna wenye kampuni, wale wako na shares mingi, kuna wale wako na chache, kuna wale hawana. Sasa nyinyi mliinvest kwa hii kampuni ya William Ruto na Rigathi Gachagua. Sasa lazima mvune. Yule ambaye alipanda atafanya nini? Si mlipanda? Si mliamuka mapema? Mkasema mtaki kusikia mambo ya ile system na nini? Mkainvest, mkapanda, mkapalilia, mkaweka mbolea, mkamwagilia maji, wakati ya kuvuna ndio huu. Na itakuwa namna hiyo. Na hiyo wengine wananikashifu ati mimi nasema ati wale walipanda wavune kwanza. Iko makosa? Iko makosa? Hata hao watavuna lakini wangoje. Si wale walipanda na wavune kwanza. Wakishavuna wavune ile tabaki kidogo, wale wakupanda waingie watafute huko nini ile itapatikana wachukue wakwende. Si iko namna hiyo? Na itakuwa namna hiyo. Ndio watu wakipiga kura waelewe hii kura ni kusema nini. Hii kura iko na maana. Nyinyi hamwezi piga kelele huko, mpige kelele. Mnasema William Ruto ni bure, hawezi, mnaita yeye majina, alafu akipata, akigawa, mnapiga laini atibuko pale mbele. Ati mnataka mpite wale walisema anafaa atibukue pale mbele. Inawezekana? Mimi kazi yangu pale kwa Ikulu ni hiyo. Ni kupanga hiyo laini. Hapo ni kazi mimi napanga hapo. Mimi naangalia kwa laini, nikiona wewe ulipanda, natoa wewe nyuma, napeleka wewe mbele.
Mr. Speaker, in the interest of time, I have 14 other videos that the Deputy President is recorded speaking in different parts of the country. Same language. Saying that Kenya is a company, and a company belongs to shareholders. It is clear from the clip. I am not the one who made that clip. The person talking in the clip is none other than the Deputy President of the Republic of Kenya. Mr. Speaker, the office of the Deputy President is a national office. The territory of the Republic of Kenya is defined in the Constitution. The territory of the Republic of Kenya is known. The ethnic communities of the Republic of Kenya are all supposed to enjoy benefits from the government. And therefore, I am inviting members of this assembly to find that the Deputy President has breached all the articles of the Constitution as contained in this ground. Mr. Speaker, it needs no gainsaying that divisive ethnic politics are dangerous. You need not look further than the country of Yugoslavia. What ethnic politics did to the country of Yugoslavia. You need not look further than the country of Bosnia. What ethnic politics did to the country of Bosnia. You need not look further than the country of Rwanda. What ethnic politics did to Rwanda. You need not look further than the country of Burundi. What ethnic politics did to the country of Burundi. Until today, they are trying to reconfigure their state. You need not look further than Sudan. What ethnic politics have done to the good Republic of Sudan that was once a stable state. You need not look even further than the country of Nigeria. Mr. Speaker, Ethiopia. Mr. Speaker, our own country, Kenya, 2007, we experienced post-election violence. You would remember that in 1992, there were clashes in Molo. And Mr. Speaker, character is important in evidence. The Deputy President, there is evidence to show that during the post-election clashes in Molo, he was a district officer in Molo. Character is very important in deciding evidence and in persuasion. Mr. Speaker, in 1992 there were clashes in Likoni and our tourism has never recovered. Mr. Speaker, we need not go that direction again. And a person occupying the high office of the Deputy President, if they want to take Kenya in that direction, the time has come for the National Assembly to stand on its feet to defend the Constitution and to impeach the Deputy President. So that even if not on any other ground, for purposes of dividing Kenya, the Deputy President today must be impeached. Mr. Speaker, allow me to turn to my ground two. Mr. Speaker, on ground two, I am alleging that the Deputy President has violated Article 147(1) of the Constitution and has also violated Article 152(1) of the Constitution. Because all of us are not lawyers, please allow me, for purposes of clarity, to read those two articles for members to appreciate. Article 147 of the Constitution does state as follows. Functions of the Deputy President. The Deputy President shall be the principal assistant to the President and shall deputize for the President in the execution of the President's functions. Article 152(1) states as follows. Composition, the Cabinet consists of the following. 1, the President. 2, the Deputy President. The person I am pleading to the House today to impeach is a member of Cabinet. C, the Attorney General. And D, not fewer than 14 and not more than 21 Cabinet Secretaries. Mr. Speaker, the importance of this is to show that the Deputy President is assigned to assist the President and is a member of the Cabinet. And what we are demonstrating, Mr. Speaker, because of time, is that the Cabinet has been making decisions. The Deputy President sitting in Cabinet, Cabinet memos come before Cabinet, they are discussed in Cabinet, and then the Deputy President moves out of Cabinet to contradict those decisions. In proving this, I am relying on the affidavit of Mercy Wanjau. Mercy Wanjau is the Secretary to the Cabinet. And in our affidavit that is in my bundle of documents, at page 77 to 79, Mercy Wanjau does, in oath, state that the Cabinet made a decision to rejuvenate Nairobi River. And when that decision was made, because the law requires that settlement be 30 meters away from a river, the Deputy President was sitting in Cabinet. The Deputy President is actually the President is actually the chair of cabinet subcommittees, and I believe he chaired the cabinet subcommittee that made this decision. However, for political expedience, immediately after the decision was made, the Deputy President moved out of cabinet and went to the public to oppose the decision. Mr. Speaker, that is inconsistent with the principle of collective responsibility. During his televised interview yesterday, that is inconsistent. The Deputy President said that if you have, once a decision is made, you need to live by that decision. During his televised interview yesterday, the Deputy President said that he's the most compassionate person. He cares so much about the poor. This afternoon, honorable members of Parliament, I want to ask the following question, and if I may be heard in silence. The Deputy President of the Republic of Kenya is on record as being the person who ordered demolitions in Mavoko constituency in Athi River. Yesterday, he gave half-truths to Kenyans, saying he opposed this cabinet decision because it was unconstitutional, because he's very compassionate about Kenyans. Why didn't he also go ahead to say that he's also the one who led demolitions in Mavoko constituency? Are the people of Mavoko constituency lesser citizens of this republic, or is it because in his own thinking they are not shareholders of this republic? And therefore, I'll be pleading with honorable members to find that the Deputy President has breached the particular articles of the Constitution by being averse to the doctrine of collective responsibility and by contradicting the President and Cabinet decisions. Quickly to ground three. Mr. Speaker, ground three.
Tangu mtupatie nafasi ya uongozi, sijapata nafasi ya kuja kusema asante. Nataka kutoka kwa roho yangu ndani, watu ya Kayole, asanteni sana. Mimi najua nimeona iko shida ya watu ambaye walibomolewa, si ndio? Na nimeona mumeandika vizuri ya kwamba mteue kamati ya watu wachache ndio mkuje niketi na nyinyi. Mtakubaliana? Mimi ningetaka wale watu ambaye walipata shida hii ya ubomoaji, ambaye ni kitu tulikuwa tumeahidi wananchi haitafanyika kwa serikali yetu, mimi ningetaka niwasikize na nitapanga na mheshimiwa Meja Dong wakuje ndio tukue na nafasi ya kuongea. Tumekubaliana? Tumekubaliana? Tumekubaliana?
Mr. Speaker, that is beyond the affidavit of Mercy Wanjau, which is on record. That is a live video depicting the Deputy President contradicting a cabinet decision, a decision which he sat in cabinet in terms of making the decision. I now proceed to ground number three because of time. Under ground number three, Mr. Speaker, the Deputy President has breached Article 62 of the Constitution, Article 10(2) of the Constitution, Article 174 of the Constitution, Article 186 of the Constitution, and Article 189 of the Constitution. Briefly, these articles relate to the functions of county governments and the cooperation with which the cooperation framework between the national and county government. And Mr. Speaker, then we are relying to prove this ground on the affidavit of His Excellency Johnson Sakaja, the Governor of Nairobi, which in our bundle of documents is contained on page 80 to 84 of my motion. We will also later rely on the oral testimony of Governor Sakaja. And basically what we are saying is that the work of regulating markets is an exclusive function of county governments. And the county government of Nairobi is a government that is independent, but also independent of the national government. And where a function of a county government is independent of the other, the national government has no mandate at all to interfere in the execution of that document. And in the affidavit of Sakaja, as members would know, Sakaja does state on oath that the county government of Nairobi made a decision to relocate traders from CBD, and the Deputy President, recklessly and without regard to the high office that he holds, went to incite people to obey lawful decisions of the county government of Nairobi, hence undermining devolution. Mr. Speaker, we invite members to find that the Deputy President did breach and violate the Constitution in terms of undermining devolution and in terms of interfering with the running of the city county of Nairobi. Mr. Speaker, allow me now to move to ground number 4. Ground number 4 is about intimidation and vilification of judges, which is contrary to Article 160 of the Constitution. Article 160 of the Constitution speaks to the independence of the judiciary. Mr. Speaker, in our bundle of documents, at page 145 to 163, we have attached the decision of Lady Justice Esther Maina, where the Lady Justice Esther Maina found that 200 million shillings assets of His Excellency Rigathi Gachagua were proceeds of crime, and directed that the same be forfeited to the state. In intimidating the judge, the Deputy President, in a public statement, accused the judge of corruption and did state that he will file a petition for the removal of the judge solely because the judge found him culpable of crime, of economic crimes. Mr. Speaker, you see, in terms of rule of law, Parliament makes laws. The judiciary interprets those laws and makes decisions. Members of Parliament must ask themselves what kind of a country we shall have if a judge makes a decision that does not favor me, then I will resort to personal vendetta against that particular judge. Mr. Speaker, I will be playing shortly a clip where the Deputy President did threaten to occasion the removal of Justice Esther Maina on ground of our finding that he was culpable of money laundering. I request the media team to play the clip in evidence.
On its threat, with the Deputy President Gachagua now filing a petition to push. Now we begin the bulletin with the war on the judiciary, where Kenya Kwanza administration is making good on its threat, with the Deputy President Rigathi Gachagua now filing a petition to push for the removal of a judge from office.
Gachagua says he will on Thursday file a petition with the Judicial Service Commission to push for the removal of Justice Esther Maina, who handled an economic crimes case against him in 2022 for alleged corruption and misconduct. Now, speaking in Iten, where he accompanied President William Ruto for a church service, Gachagua told the Chief Justice to first clean up her house by dealing with pending cases with the Judicial Service Commission. Now, in the sustained onslaught against the judiciary, President William Ruto vowed to deal with unnamed government officers he described as incompetent, saying his administration will slay the corruption monster that has reared its ugly head in various arms of government. Chamitai Goin reports.
After Chief Justice Martha Koome invited Kenyans with complaints over the conduct of judicial officers to submit their lamentations to her office, the Kenya Kwanza administration, through Deputy President Rigathi Gachagua, has taken the challenge, with the DP announcing that he will file a petition this week.
Amechallenge sisi tutoe ushahidi. I will lead by example. On Thursday, this coming week at 2:15, I'll personally present a petition before Lady Chief Justice Martha Koome against Justice Esther Maina for her removal from the judiciary for misconduct and corruption. Mimi mwenyewe nitaongoza, because Sasa unajua sasa si ametuuliza. Sasa tuko tayari. Mimi ndio nitaongoza kwa executive.
Gachagua reliving his July 2022 incident where 202 million shillings was seized to the state after Justice Esther Maina ruled the money was proceeds of corruption having been acquired through dubious means.
Huyo judge through corruption declared my hard-earned wealth proceeds of crime without giving me an opportunity to be heard. Against the rules of evidence, where he who alleges must prove. We made an application to cross-examine the investigator akakataa kwa sababu anajua there is no case. Na evidence tuko nayo vile ilifanyika.
The Kenya Kwanza Battalion.
Mr. Speaker, I would request that we pause the video in the interest of time. In the interest of time, we pause the video. From the utterances, Mr. Speaker, it is clear that the attack on the judge is based on the decision the judge made in performing a constitutional mandate as a judge. It is clear that this is personal vendetta. It is clear that the Deputy President was threatening the judge. It is clear that this is intimidation and an attack on the independence of the judiciary. Mr. Speaker, the Deputy President is a president in waiting. And if he cannot, he's a president in waiting. And if he cannot protect and uphold the independence of the judiciary, that becomes a dangerous man. And he must be impeached for that particular reason. Mr. Speaker, I will therefore be requesting members of this House to find that this allegation has been proved to the required standard and approve the impeachment of Rigathi Gachagua from the office of Deputy President. On ground number 5, we have alleged that the Deputy President has breached Article 3.1 of the Constitution, Article 148.5 of the Constitution. Mr. Speaker, Article 3.1 of the Constitution is about adherence to the Constitution. It states, for avoidance of doubt, as follows: that every person has an obligation to respect, uphold, and defend this Constitution. Article 148.5 is about the oath of allegiance that the Deputy President took on assumption of office. And in that oath, the Deputy President did take oath and swore to protect and uphold the Constitution. I have demonstrated in all the particular incidences above that he has not lived up to the calling in the oath of office. And therefore, I'm calling this House to find that the Deputy President has not been upholding the Constitution and has run averse to his oath of office in terms of his conduct as highlighted above in the allegations that I have already proven. And for that reason, Mr. Speaker, to find that ground number 5 is also proven. Quickly running to ground number 6, and there is enough evidence, Mr. Speaker, to prove that particular ground. Ground number 6 is breach of the National Cohesion and Integration Act, particularly Section 13(1) and 62 of the National Integration and Cohesion Act. Mr. Speaker, the two provisions read as follows. Section 13 reads as follows: it is an offense for any person to use threatening, abusive, or insulting words or behavior where the person intends to stir feelings of ethnic contempt, hostility, violence, or discrimination. Section 62, on the other side, provides as follows: that a person commits an offense when the person makes statements that are intended or are likely to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. Mr. Speaker, in proving ground number 1, in terms of violation of the Constitution on national unity, I did provide evidence that the Deputy President has been using the shareholder language, has been terming the Kenya government as a company. And as much as those words offend the Constitution, similarly, they offend the national Cohesion and Integration Act. And by the same evidence, I invite members to find that the Deputy President has breached those provisions of the law. Mr. Speaker, turning now to ground number 7. Ground number 7, and this is important for members to know, is that serious reasons to believe that His Excellency Rigathi Gachagua, the ground is about serious reasons to believe. So all you need is to believe. All you need is to believe that he has committed crimes. All you need in law is to believe that Rigathi Gachagua has committed crimes. That is the threshold. If in your mind you believe that Rigathi Gachagua, by the narration that I'm going to give, has committed crimes, then you vote in the affirmative. Serious reasons to believe that Rigathi Gachagua has committed crimes under sections 45, 1A, 46 of the Anti-Corruption and Economic Crimes Act, and sections 2, 3, 4, 7 of the Proceeds of Crime and Money Laundering Act. And Mr. Speaker, our allegation here is that the Deputy President, in the last 2 years, has amassed wealth that during the short period that I was able to do research totals to about 5.2 billion, which is inconsistent with his known sources of income and with his last declaration of income. Mr. Speaker, it will be remembered that during the presidential debate, the Deputy President did declare that he was worth 800 million. It is also known by virtue of the gazettements by the Salaries and Remuneration Commission that he earns $1 million or thereabout per month, and therefore he needs to show where he got the money to amass these properties. The import of my allegation is twofold. Number one, there is what we call unexplained assets under the Anti-Corruption and Economic Crimes Act. And number two, there is money laundering. Mr. Speaker, in my motion, I have listed a total of 22 companies that I believe the Deputy President has been using, number one, to amass, to award himself through conflict of interest, businesses in his office and in government. And number two, to purchase properties using unexplained sources of income. Mr. Speaker, it will be remembered that yesterday during the televised interview, the Deputy President went through all the companies and they did not deny that either of them belongs to him. All he did was to say that he registered some of them before he became Deputy President. I am not interested in the time that the companies were registered. I am interested in what the companies have done in the last 2 years. And I will demonstrate that these companies have actually done economic crimes against the people of Kenya. Mr. Speaker, I have also listed properties. I have listed a number of properties that the Deputy President has purchased within the 2 years that he has been in office. I have listed Treetops Hotel in Nyeri. I have listed Olive Gardens Hotel. I have listed Queensgate Serviced Apartments. I have listed Wamunyoro Investments land in Embakasi. I have listed the Aberdare Treetops Hotel, Outspan Hotel, Olive Gardens Hotel, and the Vipingo Beach Resort. Mr. Speaker, you will be told by the defense that some of the properties that I've listed do not belong to Rigathi Gachagua, but they belong to the estate of Nderitu Gachagua. Mr. Speaker, as you listen, please know that this man is not fond of telling the truth. And I will prove to you, and I want you to listen to me very carefully, that Mr. Rigathi Gachagua, it is true that he was one of the administrators of the estate of his late brother. It is easy to hide under the dead because the dead cannot come to give evidence. But also, there are documents. I have with me the joint will executors report on the status of the estate of Nderitu Gachagua is that 27th June 2024. This is a valid document that is part of our bundle of documents, and that also I have seen is part of the documents that came through public participation. And in this document, what the Deputy President has not told Kenyans, and listen to me, because the Deputy President actually committed another crime yesterday, misleading Kenyans. What the Deputy President has not told Kenyans is that in those 2 years, he is the one who has bought the properties of his own brother through coercion. And I am not interested, I have no problem with people owning property. What I have a problem with, and this is what he needs to be explaining to us, where did you get the money to buy these properties? This is the big question. This is a big question. Mr. Speaker, you will be told that when I became Deputy President, I transferred my companies to my 2 sons. And my 2 sons are the best entrepreneurs that Kenya has ever produced. They are the best investors that Kenya has ever produced. And one day they walked into a bank and they got a loan of 600 million. Mr. Speaker, I have looked at the ID numbers of the 2 sons, and I can confirm that they are in their early 30s. I want Kenyans, Gen Zs, you were in the streets. I want Kenyans to tell me which Kenyan, 23 years old, can walk into a bank. Where do you get the security to secure 600 million loan? I started by saying all you need to do is to believe that His Excellency Rigathi Gachagua has committed crimes. And buying properties worth 5.2 billion within a period of 2 years is not reason enough to believe that he has stolen from the Kenyan Republic. What else then will be a reason to believe? If a 28-year-old can be alleged to have walked into a bank and gotten a loan of 600 million, what else is a serious reason to believe that an economic crime has been done? Mr. Speaker, at page, shortly, Mr. Speaker, I have therefore proven that the Deputy President indeed is the one who bought through coercion the estate of his late brother. The source of funds to buy the estate is not known. Also in my bundle of documents, Mr. Speaker, there is a company called Crystal, and this is a very interesting company. This company called Crystal is the one that bought Aberdare Safari Hotel. And I have exhibited at page 122 of my bundle of documents a transfer document transferring the ownership of Aberdare Safari Hotel from the original owners to the children of the Deputy President Rigathi Gachagua at a consideration of 535 million. And this transfer, Mr. Speaker, was done on the 22nd November 2023, immediately after the Deputy President assuming office, and telling Kenyans that he found empty coffers. He was able, within 2 months, to buy a property worth 535 million in Nyeri. Which empty coffers did he find? The other day, I have exhibited at page 118 the CR12 of the new company, which shows that his 2 sons are the directors. I have also exhibited the transfer document to show that actually the ownership of the company did shift at a cost of 535 million. And therefore, I believe I have discharged my burden of proof to the required standard. Mr. Speaker, yesterday, the Deputy President said he immediately became Deputy President. He asked his children not to do business with government. But you will realize, because he's speaking from both sides of his mouth, you will realize that even in this transaction about hotels, Treetops belongs to Kenya Wildlife Service. Yes, it is true he has leased. But if you say that you have instructed your children not to transact with government, and then you lease an hotel owned by the government, are you not transacting with government? Are you not transacting with government? And therefore, the live interview by the Deputy President yesterday is a further ground for the Deputy President to be impeached. I can go on and on and on. to show that the Deputy President did purchase Kuruwitu Home Resort at a cost of 250 million from the estate of his own brother. Mr. Speaker, you were told also that Vipingo Ridge Hotel is a property within the estate of the late brother to the Deputy President. But I have exhibited in my bundle of documents CR12. CR12 is a document that shows the company directors, showing the children of the Deputy President as directors of Vipingo Hotels. The children of the Deputy President are not listed in the will as executors of his estate. So one would wonder, because they are not listed as executors of the estate of Nderitu Gachagua, then where do they come in terms of owning the Vipingo company? It can only be by way of purchase, it can only be by way of money laundering. Mr. Speaker, one other reason why I have provided the 20-something companies and the properties is also to demonstrate character. Some of these companies have not transacted. It is my prosecution theory that these are special purpose vehicles for purposes of money laundering and for purposes of preparation for money laundering. And therefore, one would wonder why the Deputy President would have so many companies that are not active, except for the reason of waiting for a prime day for them to launder resources from government. Mr. Speaker, I have also listed many companies and suspicious transactions where companies were being paid as much as 100 million from the office of the Deputy President. They are paid in the morning, and at noon they are withdrawing the money in cash. You are aware that under our regulations, you cannot withdraw more than 1 million shillings from the bank. But I have listed in schedules where in a singular day, as many as 10 transactions, cash transactions, were being done from monies that had been paid from the office of the Deputy President. These are serious reasons to believe that the monies were being withdrawn for suspicious reasons. And for that reason, Mr. Speaker, I believe I have discharged my burden of proof, and this ground is proven beyond the required threshold, and it should be confirmed as a ground of impeachment. Mr. Speaker, allow me to proceed to ground number 8. Ground number 8 is about breach of Section 132 of the Penal Code and breach of Section 129 of the Leadership and Integrity Act. Basically, these are about misleading the public. Mr. Speaker, on this one, I rely on the evidence of the video in the case of Justice Esther Maina, that the Deputy President did mislead the public that Justice Esther Maina was corrupt, simply because she had made a finding that was against him. Mr. Speaker, I also rely on a video that I'm going to play shortly, that the Deputy President did attack the National Intelligence Service in a televised television interview in Mombasa. Mr. Speaker, in that televised interview, and you will see it shortly, the Deputy President misled the Kenyan Republic on several accounts, which I will discuss after the video has been played. I now request the media team to play the video on NIS in Mombasa.
Where did the rain begin to beat us? Where did we stop listening to the people? President William Ruto and I were the darling of the Kenyan people. By listening to them, by engaging them. And as a government, we have established institutions to ensure we not only listen to Kenyans, but also genuinely understand their concerns. We invest significant resources in these institutions, particularly the National Intelligence Service, for this purpose. It is clear there has been a failure in the intelligence and advice we are receiving, particularly concerning crucial government policies. The President of the Republic of Kenya today has admitted that it has come to his attention that the people of Kenya did not want anything to do with the Finance Bill 2024. The President, and I sympathize with my boss, President William Ruto, because this information was not available to him. I know President William Ruto. Had he known 2 months ago that the people of Kenya did not want anything to do with the Finance Bill 2024, he would not have asked his parliamentary party to push it through. Yet, we have an organization paid by the public to give him and government such information. And that is where the problem is. Such information. And that is where the problem is. We have a dysfunctional National Intelligence Service that has exposed the President, the government, and the people of Kenya. Had the National Intelligence Service briefed the President 2 months ago about how the people of Kenya feel, Kenyans would not have died. Property would not have been destroyed. Offices would not have been touched. There would have been no mayhem. But they slept on the job. It had to take people to die, property to be destroyed, protests across the country for the President to know the truth of what the people of Kenya feel. Yet, there is an organization paid for by the public to brief the President and the government about the feeling of the Kenyan people.
With your permission, Mr. Speaker, I request that we pause the video because
of the national...
we have already displayed the context. Mr. Speaker, the point I'm making here is simple. That this is the Deputy President of the Republic of Kenya. By virtue of being the Deputy President of the Republic of Kenya, he is also a member of the National Security Council. The NIS is also in membership of the National Security Council. And therefore, the Constitution has provided fora where the Deputy President, in case he has any concerns, he can raise them within the official structures of government. Instead of doing that, he chose to be reckless, with complete disregard of the office, of the high calling of the office that he holds, the office of the Deputy President. It will be remembered that at this particular time, the country was at a security crisis, and inflammatory remarks would have led to the country disintegrating. Inflammatory remarks would have led to the social fabric of this country tearing apart. And therefore, by such doing, I am inviting the House to find that the Deputy President did mislead the public. The Deputy President did live below the expectations of the office that he holds, made unfounded, sensational statements, and therefore that ground should be upheld for his impeachment. Mr. Speaker, further to that, in the oath of allegiance to office, the Deputy President swore, and I quote, to refrain from directly or indirectly revealing such matters as shall come to my knowledge in the discharge of my duties and committed to my secrecy. Mr. Speaker, as you would notice in that clip, the Deputy President says that he has been told in confidence. Mark the words, I have been told in confidence by officers of the following. And while aware that he took an oath not to divulge information that comes to him, I'll be inviting this House to find that the Deputy President breached his own oath of allegiance to office. And a person who breaches his own oath of allegiance to office is not fit to hold the office of the Deputy President. I therefore urge members to find that this ground has been proven to the required standard and uphold it for impeachment. Under ground 9, Mr. Speaker, on gross misconduct. Gross misconduct has been defined as the dereliction of duty in the Black's Law Dictionary. Gross misconduct has been defined as the dereliction of duty, unlawful or improper behavior. Mr. Speaker, we have alleged that the Deputy President did breach Article 151B of the Constitution in his utterances against the National Intelligence Service, and that is incompatible with the high calling, dignified status, and the discretion required of the office of the Deputy President. And because I had laid basis in the foregoing ground, I wish to urge members, using the same evidence that I've adduced above, to also find that ground number 10 is also proven. Ground number 9, that is. On ground number 10, gross misconduct on insubordination. We have the evidence of Mercy Wanjau in the form of an affidavit that cabinet makes decisions and the Deputy President defies. I have video clips in Nyanza where the President did direct. In fact, he said it is primitive for people to say that certain sections of the country cannot receive development by virtue of how they voted in the last elections. And then immediately thereafter, the Deputy President repeated his shareholder Kenya government company utterances, directly contradicting the President. In that arrangement, Mr. Speaker, I am submitting that that is insubordination, and the evidence that we have tendered in the interest of time on record is enough to prove that ground, and members should be able to approve that the Deputy President, His Excellency Rigathi Gachagua, has been undermining his boss, has been undermining cabinet, and therefore is guilty of the offense of gross misconduct in terms of insubordination. Mr. Speaker, I come to a very interesting last one, which is that the Deputy President has breached Article 151B and Section 34 of the Leadership and Integrity Act. Mr. Speaker, in my bundle of evidence, I have the affidavit of Dr. Andrew Muller, which I would want displayed. Dr. Andrew Muller, Mr. Speaker, was the acting CEO of the Kenya Medical Supplies Agency. Kenya Medical Supplies Agency, through funding of the Global Fund, did advertise for a tender for purchase of mosquito nets to benefit Kenyans. The tender was worth about 3.7 billion. In this affidavit, Mr. Speaker, Dr. Andrew Muller avers that when he came to KEMSA, and Mr. Speaker, the witness is before the House, but because this is not the trial chamber, we will not lead him in evidence, nor will he be cross-examined, but he's ready to be cross-examined when we go to Senate. He avers that when he was appointed as an acting CEO of KEMSA, and he came to office, he found the tender ongoing, and one day, the Deputy President called him, threatened him, so that he could release a bid bond. In his testimony, he says that a company that was being funded by the Deputy President, if you allow me just to get because this is important, at page 70 to 76, at page 70 to 76 of my bundle of documents, Dr. Andrew Muller avers that His Excellency Rigathi Gachagua called me from his mobile phone. The number is provided. On my mobile phone number, the number is provided, and pressured me to surrender to his proxy the original bid bond submitted by Sobika Impex for the above tender. He told me that he would send a proxy to collect the original bid bond. He goes further to state that Dr. Ikuno Rigathi, who is a son to Rigathi Gachagua, the Deputy President, called me and sent me a WhatsApp message from his mobile phone number, which is provided, claiming to be acting for and on the instructions of His Excellency Rigathi Gachagua. He asked for Sobika Impex Private Limited's original bid bond for the above tender, which he said His Excellency Rigathi Gachagua was trying to collect from KEMSA. Annexed here to and marked AM1 are the screenshots, and I would like them, they are already displayed on the screen of those messages. He goes further to aver that Dr. Ikino Rigathi, His Excellency Rigathi Gachagua sent a one Ogora Wilson Okulo of national identity number that to collect the original bid bond submitted by Sobika Impex Limited. He concludes by saying that given the status, power, threats, influence of the people involved in the interference with the investigations and the cover-up of the irregularities surrounding the procurement of treated mosquito nets, I was constrained to surrender the original bid bond to Ogora Wilson Okulo. In short, members, please listen to this. In short, I was caught in a tricky situation, as there was nothing much I could do as a junior government officer against a sitting Deputy President of the Republic of Kenya. Mr. Speaker, this allegation was admitted by none other than the Deputy President yesterday live on his interview or live on television. He did confirm that, yes, he called Dr. Mulo. He also confirmed that he called him in relation to a bid bond. And he did confirm that the company called Sobika, the local representative of Sobika, is a company called Crystal. And the company called Crystal is owned by none other than Rigathi Gachagua and his children. And therefore, there was a direct conflict of interest that the Deputy President, that the local representative of Sobika, which is an international company registered in India, is a company owned by the Deputy President. And the Deputy President is making a call regarding a tender to a junior government officer. I wonder how many other calls he has made. But I do not need to belabor this point, because none other than the Deputy President himself did admit on live television yesterday that he did make the call. It was in relation to the bid bond, and therefore I urge members to adopt the evidence of Dr. Andrew Mulwa as the truthful and factual evidence, exhibiting that His Excellency Rigathi Gachagua did interfere with the tendering process and also did interfere with the investigation into the same. His Excellency the Deputy President did inform the country falsely that no money was lost. Mr. Speaker, you would know that this tender was funded under the Global Fund. And the Global Fund, through letters that we have exhibited, did cancel this funding. And therefore the Kenyan people lost up to 5 billion Kenya shillings and as well a relationship with the Global Fund, which is a major partner in our health sector. And therefore to allege that no money was lost is false, because the Global Fund did cancel the tender, and also it affected our relationship in terms of funding from the Global Fund. And we had to do a lot of diplomatic work, going to WHO, going to Geneva, in order to restore our relationship with the Global Fund. Mr. Speaker, lastly, members, I have rushed through the grounds because of the time allocated. I have endeavored to provide evidence that all the 11 grounds that are proposed for the impeachment of His Excellency Rigathi Gachagua are merited, and there is enough evidence. The work of this chamber is to examine whether prima facie there is a case. the trial chamber is the Senate. And therefore, I want to plead with members of this House. It doesn't matter whether you signed the motion or you did not sign the motion. I have endeavored to persuade each one of you individually that this country requires a serious leadership. And His Excellency Rigathi Gachagua is not part of that serious leadership. I have endeavored to persuade each one of you that this country requires leaders who can respect the rule of law. This country requires leaders who can respect the Constitution. And His Excellency Rigathi Gachagua is not one of them. And therefore, I take this time to implore on each one of you, besides our political persuasions, to realize that we want the best for our country. This is the country that we shall bequeath to our children. And if the country is destroyed by reckless leaders like His Excellency Rigathi Gachagua, there will be nothing to bequeath our future generations. And therefore, persuade each one of you, please vote with your conscience, put Kenya first above your politics when you come to vote. Lastly, Mr. Speaker, members of Parliament, if you listen carefully to His Excellency Rigathi Gachagua, and I did say at the time of giving my notice of motion, I have nothing against him as a person. But I was perturbed yesterday because His Excellency Rigathi Gachagua did insult members of Parliament. He insulted the intelligence of members of Parliament. There are members here who are senior lawyers. There are members here who are senior accountants. There are members here who are teachers. There are members here who are accountants. There are members, all of us are respected in our societies. The people of Kenya have elected us to exercise a constitutional mandate in this country. But His Excellency Rigathi Gachagua did say that most of the members of Parliament signed the motion without reading it. That is an insult to your intelligence. His Excellency Rigathi Gachagua, in the live interview yesterday, did say that Parliament is a theater of the absurd. In my training as a lawyer, he who insults the jury, he who insults the jury deserves no mercy from the jury. He who insults the jury deserves no mercy from the jury. His Excellency Rigathi Gachagua has insulted you before Kenyans. I urge you to rise up to the occasion. I urge you to rise up to the occasion. Uphold all the 11 grounds. Uphold all the 11 grounds. Uphold all the 11 grounds. Mr. Speaker, there is evidence that I have not gone through. The whole issue of Wamunyoro investments and the land in Embakasi. I have evidence in my bundle of documents that His Excellency Rigathi Gachagua used his office as the Deputy President, called junior officers at the Ministry of Lands, forced them to forge documents to the effect that Wamunyoro Investment had bought the land in Embakasi long even before it had been registered as a company. That land, Mr. Speaker, belongs to a sickly civil servant. It belongs to a father, it belongs to a mother. Mr. Speaker, we must have a Deputy President who is compassionate. I watched the Deputy President yesterday on television displaying impunity and arrogance. He told Kenya, yes, I have said Kenya is a company, Mutadu. He has said that Kenya is a company. Unapologetically, he has said Kenya is a company. Is this the kind of a person you would want to be your Deputy President? Members of Parliament, I do not want to imagine that anything can happen to the sitting president. I do not want to imagine. But it is also a factual reality that something can happen to the president who is in power today. If anything, and God forbid, happens to the president who is in power today, is this the man you would want to complete the term as president? This man, honorable members, this man called Rigathi Gachagua has already said that the members of Parliament in Mount Kenya are either to Gunia, I don't know what that means, or are collaborators, and that he will take them home. He has already said that where I come from, we deserve no development in Ukambani. He has said that the people of Nyanza deserve no development. He has said that the people of Western deserve no development nor appointments from the government. He has said that the people of the coast deserve no development from the government. He has said that the people of Northeastern deserve no development from the government. Those are the people you represent. Those are the people you represent. As you rise up to vote, please have the best interest of your people at heart. I urge you, honorable members, as one of your colleagues. I urge you, honorable members, as one of your colleagues. When this motion is finally put to vote, please vote to impeach Rigathi Gachagua. Please vote to impeach Rigathi Gachagua on all the grounds. As I conclude, Mr. Speaker, I am confident that colleague members of parliament will approve this motion. And I want to assure you, in the event that you vote for this motion, I will also persuasively defend it before the Senate. And I am sure the Senate of the Republic of Kenya will also uphold, and Kenya will have a better deputy president who views the country as a whole. With those remarks, Mr. Speaker, I beg to move and call our able deputy majority leader, the Honorable Owen Bayer, to second the motion. I thank you, Mr. Speaker.
Owen Bayer, you have 10 minutes.
It's okay.
Owen Bayer, you may proceed.
Okay. Thank you very much, Honorable Speaker. Honorable Speaker, I rise to second the special motion for the removal from office by impeachment for the courage and valor in tabling and moving this motion. Honorable Speaker, in his address yesterday, the Deputy President called Parliament and this National Assembly a theater of the absurd, a house of ridicule, a house which processes trash. That's what he said about this Parliament. Honorable Speaker, just like the Deputy President, I'm a student of literature, having been taught by the late Wasamba Were and the late Professor Imbuga. In the definition, Honorable Speaker, of the theater of absurd, a theater of absurd is without plot, is directionless, is laced with stupidity, lacks thoughts, lacks coherence of ideas. It is irrational and logical. If you have read the book by Samuel Beckett, you will know that in that book called Waiting for Godot, that he actually said this Parliament is as good as that literature. Honorable Speaker, I sit in this Parliament and many of you do that. Members, are we a theater of absurd? Members, are we directionless? Members, are we stupid? That's what the Deputy President characterized this Parliament, that we are stupid, we are directionless, and we are people who are very useless to this country. Honorable Speaker, a person of the stature of a Deputy President who can say such things about this chamber does not deserve to continue to become the Deputy President of the Republic. Honorable Speaker, what is the theater of absurd, Honorable Speaker, is when the Deputy President demands that for the 8 million votes, from Mount Kenya, he should be paid 2,000 shillings, translating to 16 billion shillings, so that he can bring peace to this country. Honorable Speaker, that is the theater of absurd. That is the theater of absurd, Honorable Speaker. Honorable Speaker, the Honorable Rigathi Gachagua has committed impeachable offenses as provided in Article 150, 1 and 2. He has grossly violated the Constitution and has committed crimes under national and international law, as has been ably demonstrated by the mover of the motion. Honorable Speaker, looking at the evidence provided by the mover of the motion, Honorable Speaker, that is enough to impeach the Deputy President, and he must stand impeached by the end of the day today. Honorable Speaker, Article 131E of the Constitution says the President is a symbol of national unity. Read together with Article 147(1), that the Deputy President is the principal assistant of the President and shall deputize the President in the execution of the functions of the Presidency. Honorable Speaker, for this to happen, there must be harmony at the top, in spite of how they were elected to office. His shareholding utterances, and we saw the utterances on the TV here, as demonstrated by the mover, on the shareholding. This ensures that there's no harmony at the presidency. But what the Deputy President wants to do is to balkanize this country. Balkanize the country where, like in George Orwell's Animal Farm, there are other people who are more equal than others. And as a parliament, we must refuse to buy into the theory of the Deputy President, Honorable Speaker. Honorable Speaker, the Deputy President has taken himself and wants to be a tribal king of the Murima, ready to break the country, sow seeds of disunity for his own political gain. And this chamber, today, by the end of the day, we must have no Deputy President who wants to balkanize this country. Honorable Speaker, the office of the Deputy President is a high office as established under Article 130. The authority of his office must be exercised within the provisions of Article 10(2), which anchors this principle of national unity as core. The holder of this office must exercise this article at the highest level ever. Honorable Speaker, as Deputy President, he must be beyond reproach. Like Caesar's wife, Honorable Speaker, like Caesar's wife, he must be above any form of suspicion, beyond reproach. But Honorable Speaker, the utterances and the actions of the Deputy President brings his reputation to disrepute, because he has sown sort of disunity and he has taken a trajectory that is likely to bring balkanization of this country. For that, Honorable Speaker, we cannot continue to have a Deputy President who cannot uphold the oath of his office, and therefore Rigathi Gachagua must go. Honorable Speaker, if you look at the story of Pompey, the wife of Julius Caesar, you realize that although she had been accused of sacrilege, but the court acquitted her. But Julius Caesar actually divorced Pompey, not because of what she had been accused of, but because there was suspicion that he could have done something like that. And on that, only on that, Honorable Speaker, as a chamber, as a parliament, we have the authority and right to say this guy has brought himself to disrepute, he has gone below, and he has portrayed himself as a man who cannot be trusted with the position of a Deputy President of the Republic of Kenya, and therefore Rigathi Gachagua must go. Honorable Speaker, Article 131(2), C and D gives the President and his deputy the responsibility to promote and ensure the unity of the nation and promote respect for the diversity of the people and communities. Honorable Speaker, the Deputy President has presided over the politics of exclusion and has championed the rise and resource allocation to only one region of this country. Has the Deputy President exhibited the values of national unity and diversity? No, Honorable Speaker, he has not. He does not embrace that value, a key value of the Constitution, and therefore This deputy president must remain impeached because for him, the vocabulary of diversity and unity does not exist in his vocabulary. On that premise, Honorable Speaker, the deputy president, Geoffrey Rigathi Gachagua, must go by end of today. Honorable Speaker, Article 4, 5, and 6 of the Constitution, read together with the third paragraph of the Constitution of Kenya, reinforces the fact that Kenya is one united, indivisible state. In the same breath, Honorable Speaker, the Constitution establishes the structures of counties as units of sharing resources. However, the Deputy President has established an unlawful and constitutional structure of the country as a structure of sharing national resources, where we have now a new structure of shareholders and non-shareholders. Honorable Speaker, that is sacrilege. We cannot establish another structure of resource allocation apart from the one provided in the Constitution. But now we have a new structure where those who are shareholders in the country get more resources and those that are not shareholders don't get resources. For that new structure that he's trying to establish in this country, the Deputy President, Rigathi Gachagua, must go. Honorable Speaker, there was a time in this country, Honorable Speaker, if you allow me to say this, and I will ask you to add me a few minutes more to say this, that there was a time in this country when the Deputy Chief Justice, the Honorable Nancy Baraza, was bundled out of office because of impropriety, because of an issue that Kenyans thought was not proper. Nancy Baraza, just pinching the nose of someone. And she was bundled out of office, the high office of the Deputy Chief Justice of this country. That's what happened, Honorable Speaker. Just pinching a nose. And she was bundled out of office. But here we have a Deputy President who has committed sacrilege, trying to balkanize this country. A Deputy President who has called people names. A Deputy President who has called a member of Parliament a prostitute. A Deputy President who has amassed wealth that cannot be accounted for. For that, Honorable Speaker, just like Nancy Baraza was bundled out of office, the Deputy President must also be bundled out of office because of that impropriety. Honorable Speaker, we saw the mover has ably demonstrated to us how he took on a judge. But Honorable Speaker, it is not just a judge, it is a female judge. Honorable Speaker, probably he attacked this judge because she was a woman, a lady judge. Where is the place of women judges or women in this country if we have a Deputy President who has no respect for other female or lady leaders in this country? Honorable Speaker, for the abuse on a woman judge, a lady judge, the Deputy President must go. Honorable Speaker, I know my time is running out, but I want to say this in closing. Honorable Speaker, I want to say this. When you ever face an impeachment motion, Honorable Speaker, you'd rather have a rich dead brother who you can shield yourself with. We saw what the Deputy President tried to do yesterday. But I want to tell him that Kenyans are clever and they read through what he wanted to do yesterday. And they will not buy it. It does not sell. It won't be bought. We know who he is. We know.
Give him 1 minute. Finish up. Finish up.
He's my friend. Yes, Honorable Speaker. We know what he tried to do yesterday, but we can't buy it, Honorable Speaker, and therefore Rigathi Gachagua must stand impeached at the end of the day. Honorable Speaker, we are in this boat together. We have one character in this boat called Kenya who is trying to rock it from within. He's trying to break this country. In that event, Honorable Speaker, we have a duty, if we're in that boat, to remove this one person from this boat and toss him into the high seas so that everybody is safe. And that is the duty that we must do today. And I want to convince even those that still have doubts of whether this guy should continue. I want to convince them we are safer as Kenya without Rigathi Gachagua as deputy president of this country. We are safer as a country. The northeastern region is safer. The coast is safer. The Nyanza is safer. And all parts of Kenya are safer. Honorable Speaker, and Kenya is safer without Rigathi Gachagua as deputy president. Mr. Speaker, we do not want Rigathi Gachagua to resign. We want this house, which he has called the House Theatre of Absurd, Honorable Speaker, to impeach him so that he knows that he needs to respect institutions also. Lack of respect of institutions, Honorable Speaker, is sacrilegious for the person of the stature of a deputy president. For that, Honorable Speaker, for not respecting this parliament and the Senate must impeach one Geoffrey Rigathi Gachagua tonight, and we send him home so that he knows his place in this country. For those many remarks, I second, Honorable Speaker, and ask other members to support this question. I thank you, Honorable Speaker.
Order, honorable members on their feet, take your seats. Members on their feet, take your seats. Order, members on their feet. Ruth Odinga, take your seat. Order, honorable members, take your seats. Honorable members, I now propose the question, and you'll note that on the order paper, there is the long version of the motion and the abridged version of the motion. So those of you who want to look for details of the longer version, it is there. I now propose the question, which is that pursuant to the provisions of Article 145 and 151B and 2 of the Constitution and Standing Order 64 and 65, this House resolves to remove from office by impeachment His Excellency Honorable Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, on the following grounds. 1. Gross violation of Articles 10(2)(a), B, and C, 27(4), 73(1)(a), 2 and B, 75(1)(c), 129(2) of the Constitution and Articles 147(1) as read together with Article 131(2)(c) and D of the Constitution. 2. Gross violation of Articles 174(1) and 152(1) of the Constitution by undermining the President and the Cabinet and the effective discharge of the national government's executive mandate. 3. Gross violation of Articles 6(2), 10(2)(a), 174, 1861, 189(1), and the fourth schedule to the Constitution by undermining devolution. 4. Gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. 5. Gross violation of Article 3(1) and 148(5)(a) of the Constitution on the fidelity to the oath of office and allegiance. 6. Serious reasons to believe that His Excellency the Deputy President has committed crimes under Sections 13(1)(a) and 62 of the National Cohesion and Integration Act. 7. Serious reasons to believe that His Excellency the Deputy President has committed gross economic crimes under Sections 45(1), 46, 47(a)(3), and 48(1) of the Anti-Corruption and Economic Crimes Act, and Sections 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. 8. Serious reasons to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. 9. Gross misconduct that is incompatible with the high calling and dignified status of the office of the Deputy President, a member of the Cabinet and the National Security Council. His Excellency the Deputy President has publicly attacked and undermined the work of the National Intelligence Service and its officers. 10. Gross misconduct by openly and publicly insubordinating the President, who is the head of state and government. And 11. Gross misconduct by persistently bullying state and public officers. Honorable members, the motion is supported and the list is attached by 291 members of this House. Yes. Members, before I open the debate, I received a letter from one Honorable Wandeto purporting to withdraw his signature. I want to invite the Honorable Member to read the standing orders that are very clear. Once you append your signature to a special motion, once you append your signature on a special motion, you have crossed the Rubicon, and you cannot withdraw that signature. Honorable Otiende Amolo.
Thank you, Mr. Speaker. Mr. Speaker, shall I use the dispatch with your permission? Thank you. Yes. Thank you, Mr. Speaker. Mr. Speaker, this special motion is unprecedented but contemplated by the Constitution, and I support it. Let it be a lesson, Mr. Speaker, that be you ever so high, the Constitution is still above you. Mr. Speaker, some have told me and have told us that this is not our war. But, Mr. Speaker, they do not know that in circumstances of combat, a bystander is at greater risk than a combatant. You must choose your sides. And I've chosen, Mr. Speaker, after listening to the display of jingoism by the Deputy President, after listening to the self-entitlement for 2.5 hours, after listening to the disdain of governance institutions, this Parliament and the courts, after listening to the DP threatening that Parliament and the courts should know that it's not easy to remove a Deputy President who had 7.2 million votes. Mr. Speaker, after treating Kenyans as fools by trying to mislead on the intent and purpose of his utterances on the idea of government being a company, it was easy for me to make a decision to cast my lot with impeachment of the Deputy President. Mr. Speaker, there can be much to say on the reasons. It is easy, for example, Mr. Speaker, to talk about the confessions of the Deputy President regarding 600 million that his son under 30 years was able to acquire. And he says, without tabling any evidence, that it was acquired from a bank. But he admits, Mr. Speaker, more importantly, two things. One, that the property in issue was government property irregularly acquired without the usual procurement processes. He also admits, Mr. Speaker, that the son was able to be given, a moratorium of 1 year not to pay anything while enjoying the proceeds. And the DP thinks there's nothing wrong with that. It is for good reason that the anti-corruption laws in this country do not limit themselves to the individual.
they go to the spouse and the children. It is for such reasons. Mr. Speaker, it is also interesting that the DP admits to abuse of office. How does it do that? The DP admits to abuse of office on the issue of KEMSA. It is important, and this bears repetition, that the evidence tabled by the Honorable Mutuse includes an affidavit by Dr. Mulwa. That affidavit at paragraph 5 is very instructive, and it says that the DP's phone calls was aimed at interfering and covering procurement irregularities. And that is on a direct affidavit. But more importantly, if you look at page 69, you will see the SMSs. And that SMS, the son of the Deputy President, Dr. Ekinu Rigathi, has the courage to say that there is a document for His Excellency we are trying to collect, not for himself, not for any other company, for His Excellency. And the fact, Mr. Speaker, that the DP admits to these processes and sees nothing wrong with it is a very serious matter of integrity. But, Mr. Speaker, I'll not speak to all those two. I'll speak to a more fundamental fact. The blatant justification of discrimination and insightful utterances against Kenyans. That is where I want to focus, Mr. Speaker. Mr. Speaker, in this, the DP and have gone through the documents. There are various clips where the DP repeats this, that Kenya is a company and those who did not vote for Kenya Kwanza are not entitled to enjoy the proceeds from that company. What worries me, Mr. Speaker, is that with a straight face, the DP could appear on live television and justify these utterances. How does he justify it? He says that he is entitled to do that because there are some partisan political agreements or promises that were made. What does that mean? The DP elevates promises at a political party level above the National Cohesion and Integration Act, Section 13. He elevates those promises at a political party level above the Constitution of Kenya. There are 15 different articles that speaks against this. The fact that the DP can think that he can justify such utterances and elevate these agreements above the law and the Constitution is the clearest evidence that he must go because he has breached the Constitution. It is important to note that Article 145, 1A and C do not say that if you are respecting a political promise, then you can breach the Constitution. If that was to be the case, Article 24 would include that as a limitation. It does not include. If you want one reason, members, to impeach the Deputy President is because he has admitted to breaching the Constitution on account of a political promise. Mr. Speaker, Article 145, 1B is another interesting one, and it speaks to serious reasons to believe that the DP has breached the Constitution. You do not need the hard evidence. Members, remember, for conviction, that is for courts. We are not a court of law. Ours is to look at the evidence and see if there's a serious and reasons to believe. Those serious reasons speak to integrity. They speak to impropriety. And if you look at them and then find that there's some impropriety, then ground 7 will have been proved. Ground 7 talks of the issue of acquired property coming to 5.2 billion. What struck me, Mr. Speaker, is that the Deputy President took 1.5 hours to explain why he's not corrupt. Of the 2.5 hours, 90 minutes was to explain why he is not corrupt. The very fact that you take 90 minutes to explain you are not corrupt is prima facie evidence of corruption. Mr. Speaker, for one who is not corrupt, you can explain it in a sentence, period. To take 90 minutes is in itself prima facie evidence that there's corruption. Mr. Speaker, on the KEMSA issue, other than their affidavit and their interference, the affidavit, the DP then admits interference. Whoever advised the DP to do that live interview could not have had his interests at heart, but has made our work much the easier. Because now there are self-incriminations, confessions, and admissions that we can work with. Mr. Speaker, it is clear from yesterday's presentation that the Deputy President can no longer deputize the President. The role of any deputy under the Constitution is to deputize. Mr. Speaker, I crave for just 2 more minutes. So that, Mr. Speaker, even the fact, Mr. Speaker, it is not a ground of the impeachment by Honorable Mwangi Mutuse, but it has become a clear ground from yesterday's interview that the DP is incapable of deputizing the President. And if we needed an independent ground, that is very clear. It is also clear that the DP can no longer be part, very clear. It is also clear that the DP can no longer be part of a cabinet. It is a basic rule in terms of labor law. If you cannot work with your boss, if you insubordinate your boss, if one person is to go, is the subordinate, not the boss. Mr. Speaker, Mr. Speaker, I want to just close by addressing one issue, and it bears address. Some Kenyans, hello, Mr. Speaker, it is important to address this issue. Some Kenyans want us to divert attention from the impeachment that is before us. There is only one impeachment motion before us, and it's in respect of the Deputy President. Now, some people have said, Kufa Makanga, Kufa Dereva. Now, let me explain to you. First of all, when you say Kufa Dereva, Kufa Makanga, you must remember that in that bus there are passengers. And those passengers can die if you are reckless. In this case, those passengers are Kenyans. We as Parliament must navigate that issue so carefully that the passengers called Kenyans remain safe. Mr. Speaker, that is extremely important. Why? We are in a very unique position where we have a president and a deputy president, but we do not have an IBC. If anything happens right now, as we are going to, if we impeach the deputy president as we want to, as we need to, the position can be filled even without an IBC. But if there is no president and there is no deputy president, only the speaker can act for 60 days. Within those 60 days, there must be an election. We cannot currently have an election because we have no IBC. To have IBC commissioners, you need a president to nominate the board that will select them. Once the board is nominated and they propose a name, then the name must be forwarded again to us, and it's only the president who can nominate them. In other words, if you say Kufa Dereva, Kufa Makanga, you want absolute turmoil for all the Kenyans to die in that accident. That would be a very reckless act. Mr. Speaker, I am convinced, having looked at the Deputy President, having listened to him, that the Deputy President is not remorseful. He is not sorry for any utterances. He is not prepared to change. He is a man who must be saved from himself by impeachment. Thank you, Mr. Speaker. I support.
George, order. George Morugara. Order, honorable members, order. Order, Bensouda. Freeze. Freeze where you are.
Order, members.
Order, honorable members. I know the limits of exuberance are high. Order. Beatrice, freeze where you are. I know the levels of exuberance are high, but let's listen to those who are speaking. There's a lot of requests to speak. And I did tell you that in a motion such as this, Dr. Bukose will not ask to put the question. So let's listen to each other. Of course, the canned and band of debate cannot be ruled out in acknowledging good issues and disagreeing, but let's have some decorum. Those of you who speak, you have 5 minutes. If you can finish earlier, the better, so that many more can speak. Go on, Murugara. And members, when you are given permission to speak, if you wish to come to the dispatch box, do so. If you want to speak from where you are, do so.
Thank you. Thank you very much, Mr. Speaker. Mr. Speaker, before I even state my position as regards this motion, it is important for me to express what the views of Kenyans are regarding this motion, and especially with a hindsight of the public participation that we did, and also from the public opinion which was communicated to Kenyans through an agency that conducts opinion polls. It is vitally important to remind Kenyans that through the public participation that we did on Friday and Saturday, it was overwhelming that Kenyans were in approval of the motion, and therefore we must respect their position. We must also remind Kenyans that an agency by the name TIFA has come up with an opinion polling which again has indicated that Kenyans are in favor of the motion. Therefore, even as we debate today, even as we agonize over this motion, even as we consult the Honorable Mwengi Mutuse, as we have done from time to time, as regards this motion, it is quite clear that Kenyans are in favor of the motion carrying the day. I therefore respect the position of Kenyans. I respect the position of my constituents of Tharaka, and I do confirm that I rise to support the motion. That today, the motion that has been brought to this House to have His Excellency the Deputy President of the Republic of Kenya, the Honorable Rigathi Gachagua, impeached, carries the day by a vote to be taken by the House. I must commend the Honorable Mwengi Mutuse, who is actually my Vice Chairperson in Justice and Legal Affairs Committee, for work excellently done, and repeat the position he has made, that we are not a court of law trying a suspect. We are a House of Parliament which is required to just consider whether the grounds advanced are actually substantiated. Do we have reasons to believe that the grounds advanced are substantiated? Having listened to the mover, having looked at the documentation, and I confess we have burnt midnight oil looking at this particular motion and the supporting documentation, these grounds are substantiated. Allow me briefly to just mention but a few. Ground number one, which is on dangerous divisions in the country, is propagated by the Deputy President. The Deputy President last night admitted and tried to qualify the admission that he had likened Kenya to a company. There is total difference between likening the government to a company and stating categorically that the government is actually a company. The Deputy President, in the clips we have watched, was candid in a statement to Kenyans that the government is actually a company and that each one of us has or does not have shares in that company. The net effect of this is If you do not have shares, then you do not belong to Kenya. If you have shares, then you are more Kenyan than any other person who has lesser shares than you. This is the dangerous division which this House must frown against, and it must hold squarely against the Deputy President. The second admission he made, which is a very strong ground of this motion, is breach of collective responsibility. It has been clearly stated that the cabinet includes the Deputy President. The President is the the Deputy President is the principal assistant of the President. Having breached this doctrine of collective responsibility, and he clearly said he did so because he thought, in his view, in his opinion, it was unconstitutional to have decided the way they decided, clearly shows that the Deputy President is not able to work with the government in which he is mandated to work with. To have actually failed to assist the President so that you speak contra to what the President says is itself insubordination, as we have actually been told. The net effect is that even if the Deputy President was actually to survive this impeachment motion, our question is, where would he work? He cannot work with the President because he made another admission that this motion actually has the nod of the President. We have not had any PG, we have had no meetings whatsoever regarding this motion, but he is convinced that the President has a hand in this motion. If that is the case and he survives, who will he work with? Who will be his boss? Number two, he says whatever they do in the cabinet tinkers on the unconstitutionality. If that is what his position is, that the cabinet as it sits today would actually make decisions, which decisions they would have to execute at one time or the other, which are unconstitutional, which cabinet will he work with? Therefore, it goes without gainsaying that the personality of the Deputy President, His Excellency Rigathi Gachagua, is untenable as far as the presidency is concerned and as far as the cabinet is concerned. 1 minute more. There has been an argument regarding the companies, and Honorable Mutuse has read out the companies, which nobody seems to know exactly why these companies were formed. Exactly what was the ulterior motive of forming these companies. But what I wish to point out regarding the companies, and what Kenyans should know, is that some of the properties under which the Deputy President aid, stating that these were properties of his late brother, are actually today his properties. Most important is a property known as Kuruwitu Home Resort. This property was actually sold to another company known as Kuruwitu Properties Limited for Kenya shillings 250,000. A search of these companies indicate that Kuruwitu Properties Limited is owned by Vipigo Beach Resort Limited and John Y. Madenge. We therefore have to ask ourselves, who is Vipigo Beach Resort Limited? And CR12 indicates that this company is actually owned in shares by Keith Ekino Rigathi, Kevin Gachagua Rigathi, the estate of the deceased James Nderitu Gachagua. As we were told, these two persons named, Keith and Kevin, are not executors of the estate of the late Nderitu Gachagua. So if they actually own this company, which owns one of the properties of the deceased, purchased at Kenya shillings 250 million, then it goes without gainsaying that in fact, the Deputy President has an explanation to give regarding this. Finally, we've been told about the press statement he made in Mombasa, and this is the evidence of insubordination. The country was on fire. The country was burning. The president actually finished or completed giving what measures he would take to restore the country. The Deputy President went to Mombasa, where he gave a statement which in itself was inciting to Kenyans, casting aspersions on the government, casting aspersions on our agencies, and at the end of the day, we have also seen him casting aspersions on the judiciary, which is supposed to be an independent institution. What we are required to do as members of parliament is to prove only one ground. The rest of them may fall or may succeed. But I can assure you, out of the 11 grounds, there is cogent evidence that the Deputy President has committed acts inconsistent with his office, acts which in themselves warrant this House to impeach him today as we go to the vote. As I conclude, I urge the House, let us look at the bigger picture, which is the bigger picture of Kenya as a country. What we are doing is not to try and appease one person. We are trying to do this so that the country, and we have always asked the question, the second in command who does not work with the first in command and his team, of what use would that person be to the country? With those very many remarks, I do beg to support this motion. Thank you.
Mishimbogo. Give her the mic.
Asante sana Mheshimiwa Spika. Mheshimiwa Spika, nasimama hapa kuunga mkono hoja hii ya kumng'atua mamlakani naibu wa rais Bwana Rigathi Gachagua. Na naunga mkono kwa sababu katiba yetu kifungu 159 imetupatia sababu mwafaka za kuweza kumng'atua naibu wa rais. Na sababu ya kwanza imezungumzia kukeuka katiba. Na nikiangalia Mheshimiwa Rigathi Gachagua amekeuka katiba, haswa nikiangalia kipengele cha 10 ambacho kinazungumzia maadili ya kitaifa. Maadili ya kitaifa ikiwemo umoja, ikiwemo demokrasia, ikiwemo usawa. Mara nyingi sana amezungumzia mambo ya kwamba nchi yetu ni kama kampuni na ni ya washikadau. Na amesema ya kwamba washikadau hawa ni wale ambao tu wamepiga kura katika serikali ya Kenya Kwanza. Hivyo basi kukiuka maadili katika kifungu cha 10, kwa sababu tunajua Wakenya wote wanalipa ushuru na Wakenya wote wana haki sawia, wale waliopiga kura kwa serikali na wale ambao pia walikuwa katika upande ule mwingine, kwa sababu ni demokrasia. Unaweza kuwa upande wa serikali na unaweza kuwa upande wa upinzani. Vile vile pia tunaona katika kifungu 147 kinasema ya kwamba yeye atakuwa ni msaidizi mkuu wa rais katika serikali, na msaidizi mkuu pia atakuwa ni naibu katika zile kazi ambazo rais anazifanya. Lakini je, vitendo vyake vimeonyesha mambo hayo? Vitendo vimeonyesha ya kwamba yeye si msaidizi. Kuna wakati ule wa Gen Z, wakati rais ametoa hotuba hapa Nairobi ya kutoa mwelekeo wa kitaifa na jambo lile, yeye alikuwa Mombasa akitoa hotuba ambayo ilikuwa inazungumza tofauti na ile hotuba ya rais. Na hapo pia akatia fitina katika taasisi zetu za kiserikali na kumlaumu Bwana Nurdin Haji. Kwa hivyo imeonyesha ya kwamba yeye ni kama anachukua nafasi ile ya rais, hachukui ile nafasi ya kwamba yeye ni msaidizi. Vile vile pia umeona nini Mheshimiwa Rigathi Gachagua, huna heshima kwa kina mama wa taifa hili la Kenya. Vile vile katika huo utovu wa nidhamu tunaona sehemu ya Nyandarua alinunua shamba ambalo kina mama walikuwa wamelima mahindi, wamelima viazi, wamelima zile mushiri, alimweka pale MCA na wakavuruga hiyo chakula yote. Angekuwa yeye ana hekima kama kiongozi, angeacha vikue, watu wavune, alafu achukue hilo shamba. Lakini ni kwamba hana nidhamu na wala hana kufikiria Wakenya kama naibu wa rais, na wala hana ubinadamu. Vile vile pia sababu nyingine inakuwa ya kwamba ukikosa ufanisi, Kiingereza incompetence. Na mimi nataka niseme alikosa ufanisi kwa sababu alisema anapigana na pombe haramu na anapigana na madawa ya kulevya. Akaja kule Pwani, kazi aliyofanya kubwa ni kutukana viongozi, kusema anajua wanaouza mihadarati, atawataja, atawashika. Aliwashika. Mihadarati iko ama hakuna? Na hii pombe haramu iko Mlima peke yake ama pia iko kule magharibi, iko kule sehemu ya Nyanza na iko hata hapa Nairobi? Tumuulize yeye mamilioni ambayo ameyatumia kwa hiyo kazi yametupatia natija gani? Yamefanya faida gani? Isipokuwa kunyakua ardhi, akiandika kwa jina la mke wake ati atatengeza sehemu za kuweza kunasua vijana kwa jambo hilo. Jambo jingine ni kashfa ya KEMSA. Imezungumziwa vizuri sana vile alivyowezesha watoto wake na makampuni yake na kuiba pesa zile katika kashfa hiyo. Hatuwezi kuwa na naibu wa rais ambaye juzi na jana alikuwa milioni 800, yani kama mali yake. Hivi karibuni ati ni bilioni 5.2 kwa muda mchache tu. Pesa hivi karibuni ati ni bilioni 5.2 kwa muda mchache tu. Pesa hizo umezipata wapi? Pia umedhulumu bibi wawili wa marehemu ndugu yako aliyekuwa gavana wa Nyeri. Utakuwaje upewe flati 10 na wao wapewe 5 na ni wawili na kuna na watoto? Jamani, ni sheria gani? Tunao sheria ile ya Kiingereza.
Give her 1 minute.
Tunajua hiyo sheria imezungumzia wakati mume amekufa, yani ni mabibi na watoto ndio wanaorithi. Sasa wewe itakuwaje uchukue huo urithi wote? Mpaka hoteli umechukua, ati uliandikiwa, ati ndugu yako alikupa. Jamani, wewe kama makamu wa rais muogope Mwenyezi Mungu na ujue ya kwamba hatuko hapa sisi katika ukabila. Tukiangalia akti ile ya National Cohesion Integration Act inazungumzia yoyote atakayetumia maneno ya matusi, maneno ya kutishia ili kuweza kuleta bughudha katika makabila, yeye anatakikana ashtakiwe na amefanya makosa. Rwanda juzi na jana matamshi ya kikabila yaliwatia katika vita vikali vya kikabila, na wewe leo unataka kuleta vita katika taifa la Kenya. Tuliona Molo clashes na hata wewe unasemekana ulikuwa kwa hiyo maneno. Tuliona
Time up, Mishi. Faith Gitau.
Thank you, Honorable Speaker, for according me this opportunity. And from the onset, I support this special motion. First, our supreme law of the land expects the presidency, which includes the president and the deputy, to be a symbol of national unity. In that case, the holders of that office are expected to portray a national image as opposed to an ethnic outlook. Honorable Speaker, our Deputy President has been at the forefront in advancing a selfish ethnic agenda. For him, it is about his community and nothing more. After an election, Mr. Speaker, the government has to serve both those who voted for it and those who did not. It it was wrong for the Deputy President to advocate for shareholding in order to discriminate against the rest of the communities, which may create ethnic animosity against Mount Kenya region. As a county member of parliament, I think I have traversed this nation more than the Deputy President. Secondly, Honorable Speaker, the Deputy President, as the second in command, should act as a father figure to members of parliament and the community at large. Far from it, the Deputy President, during his tenure, has been divisive and very egocentric. For him, it is about me, myself, and I. It is unfortunate that he has lowered the status and respect expected of such high office. Lastly, Mr. Speaker, when we went to the people urging them to elect this government, we gave them an undertaking that women must be respected. It is therefore, it disturbs me so greatly when the Deputy President is at the forefront demeaning women in leadership, particularly those he perceives his enemies. He has no respect for women whatsoever. He has made a scathing public attacks on a woman High Court judge. And in addition, he has been attacking women, and especially members of parliament, me and others included in this house. And therefore, he can never, and he has no respect for women, and he can never work with women. And for those few remarks, I support.
Makali Mulu. Yeah, thank you very much, Honorable Speaker, for this opportunity. Honorable Speaker, I want to say the following. Impeachment of a Deputy President is a matter of national interest and international interest, and is on the basis of that, Honorable Speaker, that people have to be very careful with what they do with this impeachment. Honorable Speaker, I want to remind the House that we are only one of the many parts of the process. This National Assembly will be making their decision. From there, we'll go to the Senate. And there is also the courts, if need be. And this is on the basis of that, Honorable Speaker, that we must isolate personal issues from issues which make sense to Kenyans. So that, Honorable Speaker, we don't, as a House, go for what I'll call mob justice mentality, and at the end of the day, the other stages, we lose it. Honorable Speaker, in the past, this House has been thrown under the bus because of this kind of mentality, where we go, make decisions, and out there, when they go to the courts, a number of our acts of parliament have been declared unconstitutional, basically because as members, we come here and we start shouting and assuming that other people there are not watching. Honorable Speaker, what am I saying? I've listened to the grounds of this motion, this impeachment motion, and I've listened to my friend, Honorable Mutuse, making the presentation and trying to justify some of these grounds, Honorable Speaker. I want to pick a few of them and ask myself whether really they meet the expectations in terms of saying that the DP should be impeached on those grounds. The first one, Honorable Speaker, is the issue of demolitions. In this country, Honorable Speaker, when you go to our constitution, it clearly says that Kenyans have a right, they have their own rights, made a decision to carry out governance. The topmost person in terms of hierarchy is the president, is not the deputy president. So in a situation where a decision is made, and the Deputy President says he doesn't support it, the question is, should you be harassing the Deputy President or the President? Because the person who took the oath as the head of the executive is the President or the Deputy President. So on the basis of those demolitions, Honorable Speaker, it is going to be very unfair to start saying it is the Deputy President who is in supporting the President, because at the end of the day, whose decision did carry the day? That's the question. The second issue, Honorable Speaker, is the issue of shareholding. Honorable members, let's be very honest with ourselves. We are all politicians. We have been voted in. We represent constituencies. How many of you can say that you are not practicing what is being explained in this motion? How many? Let's be very honest with ourselves. Let's be very honest with ourselves that most of you, majority of you, are doing exactly what is being said in this motion. It's only that don't say it publicly. That's the truth of the matter, Honorable Speaker. Honorable Speaker.
Yes, Makali Molo, there's a point of order.
Yeah, I have no problem, Honorable Speaker.
Yeah.
I hope I'll be saving my time.
Mr. Speaker, on a point of order, my name is Steve Mogaka from West Mogrango. Is the member on the floor in order to speak about what I practice? What does he know about what I practice? Can he restrict himself to what he does and not start throwing aspersions on members of parliament as if he is in their minds and he is in their practices? He's not. Is he not out of order?
Yes, Makali.
Honorable Speaker, I really don't see any point of order there. I ignore and proceed. Honorable Speaker, the issue of the judicial officer who is being accused as one of the grounds for this. Honorable Speaker.
Order, Makali.
And Honorable Speaker.
There's another point of order here.
Point of order.
Take your seat. Yeah. Give Farah the mic.
Mr. Speaker, is the Honorable Makali, somebody I have a lot of respect for. In order to compare a member of parliament who represents a constituency and the functions of that member and somebody who is the Deputy President of the Republic of Kenya who represents the four corners of this country, and say that because the members of parliament go and develop, my presumption is that he thinks the CDF funds for one constituency cannot be taken to another constituency. But that's a different thing when it comes to national resources and the Deputy President of the Republic of Kenya.
Makali, wind up, your time is up.
You know, Honorable Speaker, I hope this is not just to drive me not to say what I wanted to say, Honorable Speaker. I can see a very deliberate move to curtail me from saying what I want to say.
Do you want
Honorable Speaker,
from Nimrod Mbai?
Honorable Speaker, you know the thing is, Honorable Speaker, and Honorable Speaker, you need to protect me on a serious. You have been protecting everybody who has spoken. Unless also, Honorable Speaker, you're on the same side of those who are supporting. Because on a serious, Honorable Speaker, I don't think it's fair. You have been protecting everybody else. You can't protect.
Order, Honorable Makali Mulu. Order, Honorable Makali Mulu. You've been sitting here since we started. Order, Makali. Not a single previous speaker attracted a single point of order. If any came, the speaker will allow it. Not a single person raised a point of order. In fact, I'm being gracious by asking you, Nimrod Mbai wants to inform you, do you want this information? If you don't want it, you go on. But for you, order, Makali Mulu. You know, when you lose your cool, you also lose the argument. So just be composed, say your bit. The speaker has no dog in this fight. Just say what you want to say, finish, and we give space to somebody else. And any member who wants to stand on a point of order, it's within your standing orders. He has said he doesn't want your information. Go on.
You know, Honorable Speaker, with all due respect, people have been making their contribution here since morning. Nobody has been shouting point of order. So, and it's my democratic position to oppose the motion.
Order.
Honorable Speaker.
Go on.
Honorable Speaker, I've been elected by the people of Kitui Central to come this house 3 times. And nobody can assume that I cannot make my contribution. Honorable Speaker, I've been saying, on the matter of judicial officer,
Wind up.
The judicial officer has been accused of corruption-related matters, Honorable Speaker. And there is a court case, or as we are speaking. Are we running away from accountability as a country? When do we allow the courts to do their work up to the conclusion that as a House we want to make this as a ground for impeachment, Honorable Speaker? This is what we are saying. There is separation of power, Honorable Speaker, and we should respect that. Third thing, Honorable Speaker, the India of officers has been called by the DP. Just called. How many of us here since morning have been called by the President? How many of us here since morning have been called by the Deputy President? Pleading with us to either support or oppose. Can you be impeached on that note? On a serious note, we need to be serious as a House. And that's why I'm saying, Honorable Speaker, from where we are seated as a House, you go for mob justice mentality, you lose it at the top there, you are trying to reduce the credibility of this House to the lowest level. I know we are already low. I wish we should not reduce it further than where we are, Honorable Speaker. Let's go for strong grounds for opposition of this motion. Is it a situation where we